Yes, sir. Yes.
Item number 1.
First item is that the husband has filed a petition seeking for transfer of 125 proceeding filed by the wife at the SGM Patnagar. And second case is I filed a transfer petition seeking for transfer of that section 13(1) petition from Bhavani Patna to Sub-Judge Patnagar.
Mediation. The best case scenario is mediation. Have a settlement, end of all the matters.
Once there was a possibility of settlement, all cases were withdrawn.
Again, that can
Earlier
be
one
that
tier
could not
was
be- could not be
there.
No, Mr.
At the
Pandit, just a moment, Mr. Joshi. Matrimonial matters can be settled at the stage of Supreme Court also. You know that.
That-
And in fact, in most of the cases before the Supreme Court, these are transfer applications
Yes.
from one state to another.
Yes.
The Supreme Court usually refers it to mediation, and most of the matters are also settled. So why don't you again try? Give it a try. Now the court will be saved from deciding whether it to allow the husband's case or the wife's case. It will be better if you can have a settlement. Otherwise, this court will not
May
hire
I
you.
suggest, my lord, earlier one TRP was also there at the instance of wife. And in that case, my lord, case was transferred to Bolangir. There is a neutral place, not Kolahandi, not Patna.
So if you can agree, I will transfer it to Balangir then.
Bolangir.
Balangir করে দাও তো। হল, হল। এইটা করছি না? তাহলে লিখুন তো।
This is
First
the
one,
earlier order, your lordship.
my order or?
No, no.
Quoted
Honorable
with-
Justice BP Satpathy.
Okay, sorry. I will say on consent I am doing.
My lord.
এটা কথা কম মিলবে তাহলে TRP 01st ହେଲା there is an application filed by the petitioner husband seeking transfer of CMC number 49 of 2024 pending before the learned SDJM Patna Court to the Court of Learned Judge Family Court Kolahandi. TRPC 2024 ହେଲା TRPC 36 of 2024 has been filed by the petitioner wife seeking transfer of CP case number 105 of 2023 from the Court of Learned Judge Family Court Bhavani Patna to the Court of Learned Judge Family Court Patna Court. Is there a family judge?
No,
there?
no,
Patna?
Sub-Judge Patna, that
Apne likh
last,
dijiye.
get it correct.
To the Court of Senior Civil Judge Senior Division
Patna.
Patna Court. In course of hearing, both Sri S.K. Joshi, learned counsel appearing for the husband Akash Kumar Pradhan.
No,
I'm the wife.
I'm sorry. For Jyotirmoy, the wife Jyotirmoy Sahu alias Pradhan, and Sri J. Ponda, learned counsel appearing for the opposite party, appearing for the husband Akash Kumar Pradhan, submit on instructions from their respective clients that both of them would have no objection if the case is transferred to the Judge Family Court, Bolangir, as it would be convenient to both parties. That's all.
my lord.
In such view of the matter, both the transfer applications are disposed of with a direction to transfer the proceeding in so and so. Hala. तो देखी करेंगे यार ठीक है तार से ठीक
Item number 2. Lordship, there is an application praying for transfer of divorce proceeding pending for the family court Bhubaneswar to the jurisdiction of Cuttack, Lordship.
somebody has appeared.
Lordship.
Somebody, there's a name appearing. C. Bhodo.
No, your lordship. Lordship is my associate. By mistake. it-
Wrongly.
Your
Yes,
lordship.
yes, okay. So you are the wife.
Your lordship.
You want it to be transferred from
Bhubaneswar to Cuttack, your lordship.
Bhubaneswar to Cuttack.
Your lordship, there is a 9-month-old ailing son and she has no source of income.
होगा नहीं सर, होगा नहीं.
Lordship, it is difficult for the
हो जाएगा, होगा नहीं.
wife
नहीं
to
होगा.
travel, but not difficult for husband.
नहीं
to travel.
होगा सर, नहीं होगा. नहीं होगा. Very rare cases I have allowed. Very rare cases, and you can argue. Show me some circumstances which will compel me to change my decision. I am willing to change my decision. Don't worry. Tell me on what ground.
Lordship, she has a ailing son, your lordship. Your lordship, the medical certificates are also attached.
What?
Your
She's-
lordship.
Hmm.
Lordship, one of the prescription is at page 19, your lordship. And another prescription is at
Prescription of the lady.
Your Lordship, the son,
The-
9 months old son, Your
No,
Lordship.
no, no. Bonita Behra. This is a lady. This is a prescription by a gynecologist.
Apology, at page 25, Your Lordship.
Hmm. That was neonatal jaundice.
Lordship.
Okay, that must have been cured. How-
Meantime,
कटक से भुवनेश्वर होगा नहीं.
withdraw, Your Lordship.
Permitted to withdraw.
Acknowledge the wife is the petitioner in this TRPC seeking transfer of the list from Barampur to Cuttack Mera. Because she is residing here with her
right.
daughter Mera.
Take notice. Notice, stay. Give a date. 29th October. That entire order will be there. Requisites will file and all those things. I'm not dictating it to save time.
CP number 204 of.
See, कर दो.
Item number 4.
May I please, Your Lordship? Your Lordship, two regular first appeals have arisen out of a common judgment, which is at Annexure 1. It was passed by the Learned Civil Judge Senior Division Nimabada. One appeal has been instituted before the District Judge Puri, and one appeal was instituted before this Honorable Court. The same has now been transferred to the Additional District and Sessions Judge Nimabada. Your Lordship, since both have arisen from a common judgment, the prayer is to transfer the appeal before the District Judge Puri to the Additional
Nimmapada.
District and Sessions Judge Nimmapada.
Okay. All right. Take notice.
Your Lordship, there is also a stay application.
Wait. Let the admission matter first be over, then we will talk about stay. How could it be filed before this court? Oh, it was in 2007.
Yes, Your Lordship.
All right. Then it was being thereafter it was all
Yes, Your Lordship.
transferred back. All right. Yes, issue notice to the opposite parties by speed post, fixing a short returnable date. Requisites be filed within by Friday. Place this matter on.
September.
कहीं out करो.
8th October.
On 8th October. आइए. Further proceedings in such and such shall remain stay till the next day.
Obliged, Your Lordship.
Item number 5.
The extension of service period of the present petitioner from 60 to 62 years as Anganwadi worker, my lord. As per government guideline annexure 2, by annexure 1, they asked me to submit my medical fitness certificate. And annexure 3 is my
No. Which is the letter? Medical certificate ପାଇଁ? Annexure 1.
annexure 1.
ଆପଣଙ୍କ ଜନ୍ମ ମାସ ଏବଂ ବର୍ଷ ଜାନୁଆରୀ 24 ତେଣୁ ଆପଣ ଜାନୁଆରୀ 2024 ସାର୍ଟିଫିକେଟ ସରକାରଙ୍କ ନିୟମ ଅନୁଯାୟୀ 2 ବର୍ଷ ବଢେଇ ଦିଅନ୍ତୁ. ଏଟା କେବେ ଇସ୍ୟୁ ହେଇଛି? 2 months prior. Yes. Then
Annexure 2 is the guideline and annexure 3 I submitted my on the
you took 2 months time to submit.
yes, ma'am.
Why?
Retirement date of that is 16/10/23. Same sir. 2 months, say 10 months.
10 ମାସରେ ଆପଣ ଦେଲେ. ହଁ ତାପରେ କ'ଣ ହେଲା?
With medical certificate, my lord.
ହୁଁ.
Thereafter, they annexure 4 they issued. The only ground, my lord, that it means that an application submitted at a belated date to continue service after superannuation is not unacceptable. But till date, I am continuing. Although 8 months already ହେଇଗଲାଣି 2 ବର୍ଷରୁ. And last of it, lordship call for instruction.
Yes.
And that has not been received, but that is the reason for which it has not been extended.
But she has submitted her willingness within time.
But they have said it is not within time.
So that is what I
Belated
wanted you to take instructions. All right. Then State Council requests for some time to obtain instructions in the matter. List this matter on.
7 September.
How to get it?
8th
8th October. Interim order shall continue. Stop. If the since the petitioner is said to be working, her current dues towards her remuneration should be paid. That's all.
January onwards.
Thao, setik thao.
Second matter same. Different, same issue, so different option.
All right, same.
Round 7.
May I please, lordship? The petitioner was working as a Bhasta Sikha, so I found out copy number 5.
During a service period, he was initially proceeding.
What is Bhasa Sikya Sahib?
Let's say, advertisement under
What is Bhasa Sikya Sahib? Your prayer, look at your prayer. To reinstate the petitioner and a service to his post as Bhasa Sikya Sahib. I'm hearing it for the first time. Is there any such
Sir.
thing called Bhasa Sikya Sahib?
Multilingual education
Achha,
program.
No, I don't know. Maybe. So what are the facts of the case?
So during my service period, I initial criminal proceedings. During that, I faced the trial and acquitted. Thereafter, I approached before the authority
Yes.
for reinstate of my service.
Yes.
Repeatedly, time and again. And the corresponding reference under annexure 4 series page 26.
They are awaiting clarification from the OPEPA, State Project Director. Isn't it?
Sir.
Oh, from government actually. The District Project Coordinator has written to the government. So let the government take a decision. Yes, Mr. Das?
Yes.
Let the government take a decision. Well, you were engaged as Sikya Sahib. Sikya Sahib likha hai, Bhasa Sikya Sahib to likha hai nahi. Sikya Sahib for MLE program. Is it known as Bhasa Sikya Sahib?
Multilingual
Language.
multilingual
The petitioner was engaged as
Multilingual
Sikya
education.
Sahib for MLE program by order dated 8/1/2014. While working as such, he was involved in a criminal case and was taken to custody. He was thereafter disengaged. When were you disengaged? The criminal case, however, being CT number 145 of 2016 of the Court of Learned Additional Sessions Judge, come Judge, Special Court Rayagada, ended in acquittal of the petitioner. Thereupon he submitted representation for being reinstated. The clarification was sought for by the District Project Coordinator, Rayagada, as to if the petitioner can, in such circumstances, be reinstated in service. Stop. The requested for a call the District Project Coordinator Rayagada. No, I will call clarification account. From the State Project Director OPEPA. Hello. Again, on 25/11/2017, the District Project Coordinator sought for clarification from the collector. From the collectorate. It is borne out from the records that the matter is still pending with the pending at the government level. Such being the case, no fruitful purpose would be served by keeping the writ application pending any further. Which is therefore disposed of, directing, will direct the secretary, will directing the secretary to government in the Department of School and Mass Education to take a decision in the matter under intimation to the petitioner.
It's a copy of your lordship.
Within 2 months from today. The petitioner shall furnish copy of the order passed by this copy of this order before the secretary. Yes, that's all.
Yes.
Item number 8.
It is that the order of my lord in the earlier case.
Okay.
I have given.
Yes.
I have also copied the order. Some doubt, but with that adjustment, your lordship will desire that this order is proceeding here is case is the appeal was number 1, 2023, but my appeal is 2022. If your lordship will say from the date of order, then your lordship order applies. I should go to the arbitration.
No, let me just see the other order.
Two occasion, my lord, appeal, second appeal lies to the RDC. First against the selection, if appeal lies to the ADM, second appeal lies to the RDC. Even if in the case of termination, appeal lies to the first instance to the
Yes.
ADM,
Yes.
and again second appeal lies to the RDC.
Yes.
Here, my lord, there is a service of already petitioner has been terminated, pursuant to the first appellate order of the ADM.
Yes.
So therefore, because this is passed in consequence to the order of the ADM, so now appeal only he can move before the RDC against the termination also. I have given both the orders, termination order and the appellate order.
In your counter.
Now disengaged, he has already been disengaged.
And he has not been allowed to, she has not been allowed to.
No, it is not my appeal, it is yes before the RDC. She is not able to approach the authority
No, in that case,
to provision.
no, the provision, I'm aware of the provision.
8G, ଆଉ ତାପରେ 10D,
Yes. Yes.
guideline.
No, in the other case, I think the course of action arose later. In the other case, the case which you are referring to,
My lord.
there he was appointed on 3/1/2023, Wahida Khatun.
Yes,
Then
prior to that resolution.
prior to that resolution,
Yes.
but who challenged it?
She was terminated at the instance of an appeal filed by the opposite party.
When was that?
Yes, Wahida Khatun in 24.
When was she terminated? Yes,
Termination hochi.
that is what gave cause gave.
Just I got the file because I was the counsel. I'm
Yes.
just telling.
Yes.
15th February 2024.
15th February 24.
Appellate order.
No, not appellate order. I'm asking when were you disengaged?
Again.
When were you disengaged?
Still, no, disengage ହେଇନଥିଲା ସେ.
Oh.
ସେ appeal order ଟା ଆସିଲା 8G ରେ ସେଟା ଥିଲା ନା ଆପଣ order ଟା ଦେଖନ୍ତୁ. ଦିଟା occasion ରେ second appeal lies. ସେ ADM order ପରେ immediately read.
No, let me understand.
Yes, sir. Fact.
Here, what has happened is you were appointed in that Wahida Khatun's case.
ନା Wahida Khatun ମୁଁ ବି opposite party ଥିଲି ସେ complain କରିଥିଲା ସେ appeal.
So, who had filed the complaint?
Complaint file କରିଥିଲା.
So what gave rise to the appeal? That is what I would
Yes.
like to know.
Selection of Wahida Khatun was challenged by Nagma Parveen. Nagma Parveen from appeal court.
Oh, so that is why
So
the
Nagma
appeal was
Parveen challenged in the appellate court.
the appeal was filed after coming into force of the this guideline. That is why.
No. Appeal was prior to that. Appeal was disposed of after the guideline came into force.
Is it a fact?
Yes, that is.
When was the appeal? When was the appeal filed?
Appeal hochi appeal number 1 of 23. Nagma Parveen.
Date केबे 15/3 ही गले
22. Appeal was filed on first.
No,
My present case is concerned. No, for present case is concerned. It is in 2022.
Yes. Here the Anganwadi in the previous case Anganwadi appeal number 1 of 2023 is right. Mr. Das is right. But
Yes.
provided if this appeal has been filed prior to 15/3/2023.
30/23 ର
That's
appointment order
right, that is
selection.
my doubt, my lord. That is my
30
doubt.
ଏଇଟା ମୁଁ ଫାଇଲ ଧରି କହୁଛି ସେଟା. Wahida Khatun case ରେ
I'd like
Wahida
to know-
Khatun was selected and appointed 3/1/2023. It
Yes.
was challenged
in the appellate court immediately.
Immediately, what is the date? Tell the date.
ସେ ଡେଟ୍ କାରଣ 5/1 ରେ ଯଦି ଆପଏଣ୍ଟମେଣ୍ଟ ହେଲେ ସେ appeal ଟା କେବେ ଫାଇଲ କଲେ that is the very relevant if the appeal has been no Mr. Das let me
Yes, sir, I'm holding.
no let I will
Page 24, the second paragraph, the learned counsel for the respondent number 1 submits that this appeal.
See, I would file it.
the connected matter I'm looking at the connected matter
Available or
just to know but if the I'm willing to concede that this order is wrong
No, I don't say wrong.
I will say wrong if
I have a doubt in my mind that if the appeal is filed in 2022 and disposed of in 2024.
that will have no impact
That
will
will
have-
be my.
no that will have no impact
I have a doubt.
but in Mr. Das's case, if the appeal has been filed prior to 15/3/2023 and this order has been passed, I am willing to admit that this is a wrong order.
I cannot say that.
I will say,
I cannot decide.
no. To her is human, sir. God.
Your Lordship has already decided the issue. Even either way, Lordship, I am agreeing. If they will say, I will go to RDC.
No, but if the appellate authority will,
Out in my mind, so far
Yes.
Your Lordship's order is concerned, if an appeal is filed in 2022 and disposed of in 2024, whether the in between.
ଆଜ୍ଞା ଟିକେ ମୋବାଇଲ କାହାର ଅଛି ଆଜ୍ଞା ଟିକେ କାଇଣ୍ଡଲି ବନ୍ଦ କରିଦିଅନ୍ତୁ ଏଟା କହିବାକୁ ପଡିବ କୋର୍ଟରେ
25/1/23 ରେ ଫାଇଲ କରୁଛି appeal petition ଟା
25/1 ତାହେଲେ
prior to guideline.
this order is wrong. This order is wrong. I am willing to admit this is order is wrong କିନ୍ତୁ ଯାହା ତ ହେଇଛି ଆଉ କଣ କରାଯିବ ଆଉ ଥରେ ଭୁଲ କରିବି
Again,
ଆଉ ଥରେ ଭୁଲ କରିବି
I don't think that order is wrong.
absolutely wrong
No,
wrong.
no, because it is the
Date of
same court.
disposal, Mr. Das, with your vast experience, you can know which is the cause of action, not the date of disposal. केबे आरंभ होला केबे appeal टा फाइल होला सेबेटु ना
No, but if suppose in normal law, I got the judgments also today. I was come across in the commercial tax cases.
अब
The law changes.
taxation भी କରୁଛନ୍ତି
ନା judgment ମୁଁ କହୁଛି taxation ମୁଁ କରିନି ମୁଁ judgment ଆଜି ଗୋଟେ ପଢୁଥିଲି
କୋର୍ଟ କି ମନା କରୁଛି nobody is ଆପଣ ମନା କରୁଛି ନା କଣ More than area.
କେସ୍ ଶୁଣୁଛନ୍ତି ଆମେ ଗୋଟେ କେସ୍ କରିପାରିବୁ
ମାନେ କରୁନାହାନ୍ତି ଆପଣ ଯେମିତି କହୁଛନ୍ତି ଯେମିତି ଆପଣ ଏତେ ଅସୁବିଧାରେ ଅଛନ୍ତି ଯେ ଆପଣଙ୍କୁ କୋର୍ଟ ବି ଦୁଃଖ କରି ପକେଇବେ
ଜଜମେଣ୍ଟ ପଢିଲା ଯେ ସେଥିରେ ଧର ଚେଞ୍ଜ ଅଫ ରୁଲ ହେଇଗଲା ତ ଯୋଉଟା ନୂଆ ଏକ୍ଜିଷ୍ଟିଂ ରୁଲ ଅନୁଯାୟୀ ଅପିଲ ଫାଇଲ ଇଭେନ୍ ଇଫ୍ ଦି କେସ୍ ଇଜ ପ୍ରାୟୋରିଟି ଆପଣ ଧରନ୍ତୁ ବର୍ତ୍ତମାନ ସାର୍
ଆପଣ 25/1 ରେ ଫାଇଲ କରିଛନ୍ତି ନା prior to the 15/3 so prior to guideline ମାନେ it will be governed by the rule existing then
no my lord that law is
no
ନାଇଁ ମୁଁ ଯାହା ଜଜମେଣ୍ଟ ଗୁଡ଼ା
unless there is a guideline unless there is something in the rules
ସେ ଜଜମେଣ୍ଟ ଏତେ ବଦଳ କରି ଆଣିଲିନି ବଟ୍ ଆଜିକା ମୋର ଯେତିକି ଲିମିଟେଡ୍ ନଲେଜରେ ମୁଁ ଦେଖିଛି the case is to be decided on the law prevailing on the date of decision.
no sir
That is the judgment of my lord Supreme Court. What shall I do?
no sir
On the date of cause of
I'll give-
action, on the
No.
date of filing.
date of cause of action
On the date of decision.
I will give you as chair I'll tell you as chair
ସକାଳେ ପଢିକି
so as chairman of sales tax tribunal I have decided a matter relying upon Allahabad High Court case where when a second appeal was filed in the tribunal there is a second appeal so it was filed it was to be, because of the pecuniary jurisdiction it was to be held by a single judge city division bench full bench bhi achi so what happened is the law changed so the sorry it was initially before a division bench pecuniary jurisdiction अनुसार division bench thila law changed so it came to a single judge so that was challenged saying that no I had a vested right that my case would have been considered by two judges and that was allowed yes because the law existing then
If you take example of our High Court rule also, now writ appeal has been introduced. All the writ petitions pending prior to this amendment of this High Court rule were before the division bench. Now it has been heard by the single bench. So those cases also were going to the writ appeal because of the change of rules.
the rule provides that here there is nothing rule does not provide that that is the problem
But this is the only guideline because
No,
this
but-
guideline.
how many you argue you file your counter let us hear this
This is the guideline.
let us hear this
File a counter. I
let
will.
us hear this
I will file the counter on merit also. That
Yes,
is
yes.
something
Yeah,
different.
that is what I'm
With
saying.
regard to that maintainability, because my lord have
Maintenance,
decided-
I'll deal with it, the final,
again.
I'll deal with it, you file your counter.
I will also
Okay.
file an amendment my lord, because of the retrenchment order I have received for yesterday. So I will file an amendment in challenging
It has
this.
already been terminated.
Sri KP Mishra, Leonard Senior Counsel, submits that he would file a petition for amendment. Sri SK Das, Leonard Counsel, appearing for the opposite party number,
Four.
private opposite party, the private opposite party submits that he would also file a counter affidavit on merits of the case.
Yes.
Any further proceedings shall be subject to result.
That is there. That is always there. Anyway, 2 weeks time is allowed to the parties for the above purpose. Let's this matter on 24th September. In the
That creates
meantime,
in my mind yesterday
this-
that whether
This the you Vaida Khatunda order to refer for so that on merit and as well as on merit.
I will pass it on.
Exactly. The Lordship
I
said,
pass
"Sir, corrected or malad, I have nothing to say, I will go to addition." But if there is a doubt in my mind,
No, Mr. Mishra, what will happen is, like this order, that order will also become a precedent. So I don't want to pass a wrong order. According to my understanding, I may be wrong. It can be, if you challenge it in the writ appeal, I'll be very happy and get it set aside.
No, no, I to say Jai se appeal chal.
I say, ଆପଣ ଜିତିଗଲେଣି, ଆପଣ କାଇଁ କରିବେ? So on your other side should have challenged it and got it set aside.
Appeal file consider appeal number.
doubt in my mind.
No, I say it in open court.
Appeal number.
I would be very happy to see my order set aside. Is it wrong order?
Nobody challenge that. Parties are not challenging. Parties
No,
are
malad,
proceeding
it can
there.
be distinguished because my case is 2022.
No, he has the date 25/1/2023 যদি appeal টা ফাইল হয়ে গেলা তাহলে 15/3 পূর্বକୁ পড়েগলা 15/3 পূর্বକୁ যদি পড়ে আসলা
Each one has
তাহলে
Oh, that's true. Then your Lordship has to examine your Lordship's own order.
so why should I do that? I will pass a right order, and when you file, I'll distinguish it, saying that that was not correctly decided or something like that. I will say something like that. Please this matter to 24th September.
ଆଉ ଟିକେ କାଉଣ୍ଟରଟା ଦେବି ଟିକେ ଟାଇମ ଲେଖି ଗଣେଶ ପୂଜା ଅଛି ତ। ତା ପର ୱିକଟା
ତାପରେ
ଜଷ୍ଟ ପର ୱିକ
30 ନେ କେବେ? 8th October.
ଆଜ୍ଞା।
I don't know, 9. In this case, the petitioner is serving as Anganwadi worker since 2002, while she is serving as Anganwadi worker, the house is in a dilapidated condition. The government is also.
Which house? The house in which?
Center house, in a rented house, it is functioning well. Government did not pay any rent towards the house rent from appeal. The petitioner has paid from his pocket money. While matter stood thus, the locality of the people, some threatened the petitioner, some supporter of the ruling party, threatened the petitioner. So petitioner shifted the Anganwadi children matter to a nearby community center, which is within the Anganwadi center. From that date, the dispute arose. Immediately, petitioner wrote to the CDPO, this is the condition, so you arrange or permit me to run the center in the community center. Instead of resolving the issue, the CDPO issued show cause that we found you have misappropriated the food articles not coming to the Anganwadi center. I wrote on 23 August
ତାର ୟା ସହିତ କଣ ସମ୍ପର୍କ ଅଛି ଆଜ୍ଞା?
କିଛି ନାହିଁ ସେ ସବୁ କହିଲେ
ନା ଗୋଟେ ତିଆରି କରୁଛ ଷ୍ଟୋରି ଆଉ କଣ?
ନାଇଁ ସେ ସବୁ କହିଲେ show cause ମାଗିଲେ ମତେ ଦେଖନ୍ତୁ you lordship kindly see he issued me show cause page 21 annexure 4 page 21 show cause mତେ issue କଲେ 24 ତାରିଖରେ I submitted my show cause reply under annexure 5 page 23 that was not accepted in the CDPO office. Your lordship will find annexure 6 page 25 that show cause I sent to the registry post that was refused page 25. Your lordship kindly see page 25 annexure 6 CDPO is a government office he is also a government official. What prompted her to refuse the show cause sent by registry post? They did not receive my show cause reply in the office, not given acknowledgement while I sent through speed post. That was refused, the postal embark is refused return to the sender. Thereafter, they directed me under annexure 9 page 29, please hand over the charge to nearby Anganwadi center worker we telephoned you, did not come for fact remains they have not telephoned me. So in obedience to their letter under annexure 9, I have already handed over the charge. On 6, they wrote me letter on 6/8, I handed over the charge on 12/8. Charge handed over. Now CDPO is not neither considering my show cause reply nor taking any step whether the center will run in the community center. Now I am not getting salary of the month of August. I have worked till 11th August last fag and jack ବର୍ତ୍ତମାନ ପର୍ଯ୍ୟନ୍ତ ପାଇନି ଦରମା ଆଉ ମୋର ବି କିଛି କୋଉଠି କଣ ଏନଗେଜ ହେବି କିଛି କରୁନାହାନ୍ତି।
Yes.
Your lordship will kindly find at page 28, annexure 8. She has last represented before the immediate authority DSWO That was last made on 5/8/2024. She has stated what she has now submitted with your lordship. So let her consider and pass an order. of-
Yeah, another representation is also there at on 28/2024, Annexure 12.
Last detail representation tax ପଡୁନା ତେବେ ଦରମା ବି ପାଉନି ମୁଁ ଅଗଷ୍ଟ ମାସର ଟୋଟାଲ ଲାଷ୍ଟ କୁ ଯାଇ ଖଟିଛି
Yes.
ଦରମା ପାଉନି ବର୍ତ୍ତମାନ ସିଏ ବସିଛନ୍ତି କେମିତି ଡିସେନେସ୍ କରିଦେବେ ବର୍ତ୍ତମାନ ଯୋଉ ରୁଲିଂ ପାର୍ଟି ଅଛନ୍ତି ତାଙ୍କ ଲୋକକୁ ଆପଏଣ୍ଟମେଣ୍ଟ
ସେ କରିଦେବେ ତ ଆମେ ଏଇখানে ମୁଁ ଡିସ୍ପୋଜ ଅଫ୍ କରି ରିପ୍ରେଜେଣ୍ଟେସନ ପାଇଁ ଦେଲେ ସେ ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜ ଅଫ୍ କରି ଆପଣ ଡିସେନଗେଜ କରିଦେବେ।
ସେଇଟା ହଉଛି ମେନ୍ ଉଦ୍ଦେଶ୍ୟ ଆଉ କିଛି ନାହିଁ
କରିଦେବେ।
2002 ରୁ କାମ କରୁଛି ୱିଦାଉଟ୍ ଏନି ମାନେ
ସୁବିଧା ହେଇଯିବ ବର୍ତ୍ତମାନ ତାକୁ ଡିସେନଗେଜ କରିବାକୁ ସୁବିଧା ହବ।
2 ରୁ ଆସି 24 ଯାଏଁ 22 ବର୍ଷ ଯାଏଁ
ଆମେ କରିଦେବା ସେ ସୁବିଧା କରିଦେବା।
ଯେମିତି ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଚେଞ୍ଜ ହେଲା ସାଙ୍ଗେ ସାଙ୍ଗେ ମୁଁ ସବୁ ଚୋରି କଲି ଅମଳା ଖାଇଲି ସବୁ ଖାଇଲି ଜୁନ ମାସରୁ ଆଜି ଭିତରେ ସବୁ ଚୋରି
କିଏ
କଲି
ଚୋରି କଲା କଣ କଲା ସେଟା କଣ କହିହବ?
ନାଇଁ ସାର୍
ସେ ଏଇଠି ବସିକି ଗାଈ କୋଉଠି ଜାଣିପାରିବି?
ବର୍ତ୍ତମାନ ତାଙ୍କ ଉଦ୍ଦେଶ୍ୟ ଅଛି ମତେ ଡିସେନେସ୍ କରିବେ ଆଉ ଗୋଟେ ଝିଅକୁ ରଖିବେ ଆଉ କିଛି ନାହିଁ
Yes, so we'll direct him, the CDPO to look into the matter.
DSW, District Social Welfare Officer.
CDPO କୁ ଦେଇଛି annex
He is
to-
above the CDPO and the
So
supervisor.
let him dispose of the matter.
Yes,
The petitioner was,
hearing the parties.
obviously, the petitioner was engaged as Anganwadi worker of कौन सी जगह था?
ପ୍ରଥମା ଖଣ୍ଡି
प्रथमा खंडी 2 Anganwadi Center
2002 ରୁ ମୁଁ ଏନଗେଜ
with effect from 18/3/2022. While working as such, a show cause notice was issued to her asking her to explain certain allegations of misappropriation, etc. She submitted a reply. She duly submitted a reply pursuant to such notice. It is her case that the reply submitted by her through registered post was refused by the CDPO. He nobody she karibo hela. She therefore submitted several other representations, including one to the DSWO Jajpur on 5/8/2024, copy enclosed as Annexure 8, wherein there is an endorsement of receipt on 5/8/2024 on the body of the representation. ଆଜ୍ଞା କିଏ ମୋବାଇଲ ରଖିଛନ୍ତି ଆଜ୍ଞା? ଆଜ୍ଞା ମୁଁ ମନା କରିସାରିଲା ପରେ ବି ଆପଣ ମୋବାଇଲ ରଖୁଛନ୍ତି ଆଜ୍ଞା କୋର୍ଟରେ? କଣ ଲେଖିଲେ? It is the petitioner's grievance that no action has been taken as yet on the representation so submitted. Stop. Considering the limited grievance of the petitioner, the representation is submitted, the writ application is disposed of, directing the DSWO Jajpur to take a decision on the representation received on 5/8/2024 in accordance with law, after granting an opportunity of hearing to the petitioner and other necessary parties within a period of 1 month from the date of production of certified copy of this order by the petitioner. Yes.
no coercive action में
No. No.
मतलब to release the salary I have worked में
So it is submitted that the petitioner is still performing her duties as Anganwadi worker.
4 दिन 12 8
Though she has handed over the petitioner, it is stated that the petitioner has handed over charge of the center pursuant to order of the CDPO. But she is officially still the Anganwadi worker of the center. So, however, she has not been paid her remuneration.
As alleged.
Alleged his per mulur. She has not been paid her remuneration, monthly remuneration. Stop. If such is the case, and if the petitioner is found to be still engaged as Anganwadi worker, officially, comma, she should be paid her monthly remuneration, comma, if not already paid, without any further delay. Yes.
Item number 10.
এসিটা বন্ধ দিয়েছি এসিটা বন্ধ করতে খুললো না yes item 11
Item 10. The petitioner while working as lecturer in political science was not allowed.
May I be permitted to? But in this case, man, on the last occasion, after expressing displeasure with the state of affairs matter for not tracing out the file. So let's.
oh yes, the chief secretary was directed to take notes. Yes, what is the report of the chief secretary? Very good.
And now the position is that, my lord, the file has been checked. And to streamline the same, an office order has been issued.
What has the chief secretary basically said?
My lord, that is in para number, page number 3, my lord. As a measure for future monitoring the court figures file checking.
The following strict actions were initiated by the director of the approval of press team was constituted with 10 officials.
Yes.
SOs and ASOs of the concerned section, record keeper and record of
Records of the supervision of the assistant director in charge of the session was instructed to take immediate steps for tracing out the file.
After a thorough search, the appeal file bearing number has been traced out and will be produced before the Honorable High Court on 3 through affidavit. Upon file court chulta.
So,
But affidavit file.
direct.
With an affidavit, matter to a filing.
Yes.
That the director had resolution. And this,
So we'll take it on record
yes,
as directed.
and this is the affidavit filed by the director.
Affidavit copy tam do put.
This, sir.
The report you need not give.
No,
Report is this is in the chief secretary and then.
and that annexure A by 1. What
I'm
it is annexed-
এই পাটাকে কই দে
no, what it has been annexed to the chief secretary's report, my lord. That is also the annexure A by 1. That annexure is also available with the supporting affidavit filed by the director.
So this A by 1 is said that he has issued a fresh order regarding tracing out of files and all that. In order to dispose of the court cases of higher education department in a timely and effective manner, all required records files will be traced out immediately or within a maximum period of the dealing estimate. Yes, this is what I wanted to be scanned at the earliest. You have to digitize all the files. I had done it in the law department. You will now find the gazette from 1937 onwards. Go to the website, you will find all the gazettes there.
Now by this order, my lord, now it will be applicable to all the department. And
It should be, it should be. No, this is for the higher education department. Specifically, because a lot of court cases are there.
Yes.
So that is why the chief secretary has passed this order, and rightly so. As directed, the chief secretary Odisha has submitted a report indicating the steps taken to trace out the file in question. Stop. It appears that a fresh team was constituted with 10 officials by order dated 23/7/2024 under the supervision of the assistant director to trace out the file. Stop. After a thorough search, the appeal file bearing number 6C-Roman 3-19 by 2010 relating to the petitioner has been traced out. Said file is being produced by the state has been produced by the state council today. In the court, along with an affidavit sworn by the director higher education in charge. It is further stated in the report that in order to avoid such instances in future, It has been further stated that for future monitoring of court cases files in a better and effective manner, several steps, including scanning of all physical files, have been taken. Stop. An office order has also been issued, copy of which is enclosed as Annexure A/1, directing all concerned to trace out all court-related files within the stipulated time, under pain of disciplinary action, under pain of appropriate action against the erring employees. Stop. The affidavit be, the report of the Chief Secretary be kept on record. Yeah. The affidavit be also kept on record, a copy of which has been served on the counsel appearing for the other side. No. The physical file.
Yes.
Shall we go through now?
Sorry to say, my lord, that it has not been flagged.
We'll take it up next week then.
Yes.
The physical file be kept with the State Council. Let's this matter next week. All right.
10th.
10th.
Yes.
I don't know, 11th.
So obvious that somebody was deliberately suppressing the file.
That person is actually retired government. Sir.
That department, my God.
Proper care. That is the problem.
Care no children, apne janna thi. Jota dorkar sera care nabe. Jota dorkar nahi sera forward do. I was very sure that the file will be traced out. Once the matter goes to the higher authorities like the Chief Secretary, everything will come up.
Your lordship's experience.
Yes,
By your lordship's experience in
happens. This court places on record its satisfaction regarding the steps taken by the Chief Secretary in the matter. Let a copy of this order be communicated to the Chief Secretary. Yes.
In item 11, my lord, I filed a IA to amend the prayer, and as per interim order, my lord, the representation has been rejected. That has been annexed, but inherently that was not challenged. Therefore, amend the
You're filing it today.
IA, my lord, I filed that 11732.
What do you say? You have any objection, Mr. Patnaik?
No matter.
Kete koile 11 house.
11.
This is an application for amendment of the writ application as per the schedule. By means of this petition, the petitioner wants to amend his prayer to seek quashment of order dated 12/8/2014 as Annexure 18. Stop. The State Council has no serious objection to the prayer for amendment being allowed. In such view of the matter,
Contradicted, my lord.
the application for amendment is allowed. Consolidated
File kori, bote.
consolidated writ application be filed within 3 days. Let's this matter next week.
I don't know.
My lord, the petitioner, first of all, she was engaged as an Anganwadi worker. But controversy arises regarding center area, Anganwadi center area. Opposite particular file lost a complaint manner before ADM. And ADM disposed of the case with a direction that the petitioner engagement is already cancelled by ADM. My lord, therefore, the petitioner come to this Honorable High Court and take a direction, take a order, my lord. Kindly have a glance at page number 15, my lord, of region to petition, my lord. Para number 4, my lord.
You were the appellant, you had filed the appeal. You are Manjulata Khanda,
I am
Sukhantilata Das. Now, this ADM's order says that this Manjulata or whatever your name is,
Manjulata Khanda,
Manjulata Khanda,
opinion 5.
her application, her residential status was wrongly not considered. And so the ADM directs the CDPO, the selection committee rather, to take further follow-up action as per government guidelines. So I think both the cases would be considered now. Isn't it?
In fact, a counter affidavit has been filed where it has been stated.
There are two, that appeal was had twice, my lord. That first part, my lord, annexed to 1, my lord. So by virtue of.
No, then again another order was passed.
Again, another order was passed.
Where is it?
That is, my lord, second part starting from page 14, my lord.
Yes.
So again, same order was passed.
How? Oh, again he had come to the court and therefore. So what was
this court, my lord, and this honorable court directed to the ADM, my lord, to hear the appeal address by causing inquiry, my lord. By the
accordingly, the order of the owner, since concurrently, hence the selection and engages Sukhantilata Das, the petitioner for the post of is hereby quashed. CDPO, you are Sukhantilata Das.
My lord,
The CDPO Khora is directed to disengage the petitioner from the work post after observing the formalities as per provisions of. Further, she is directed to take steps for convening the selection committee meeting of Anganwadi workers for selection of. So that selection committee meeting has not been held.
No, thereafter what happened, my lord? The petitioner filed challenging this order, my lord, up to this honorable court, this writ petition, and after stay, my lord. Because of that.
So that is why. So the selection process has not been concluded.
Not started because of siege continuing, my lord. Siege continuing. The petition is continuing.
All right.
Her selection was cancelled, my lord, by the ADM in the appeal, my lord.
Unless you can show how this order is wrong,
My lord.
why should this court interfere now? How is it wrong? How is this order wrong?
A dispute regarding the residence, my lord. Whether the siege residing within the service area of Anganwadi Center or the opposite partner.
What is your counter?
Counter in paragraph 5. It has been said that there was a fresh enquiry in which it was found. Your lordship will kindly find.
Tahsildar Khoira therefore conducted an inquiry in presence of Revenue Inspector Sanjaypur, Revenue Supervisor Khoira Tahsil, ICDS Supervisor Khoira City, and Anganwadi worker Tottapada. Gala. Revealed from the inquiry that OP number 5, that is Manjulata Khanda, is placed at serial number 413 of the survey list of the Godo Sai AW, whereas the petitioner was found at serial number 717. The old survey?
From the old survey register of Anganwadi worker, Tottapada Anganwadi Center, which later separated into two Anganwadi centers, namely Tottapada Anganwadi Center and Gaudasai Anganwadi Center, it was also found that the opposite party, number 5, belongs to Gaudasai. It was revealed that the house of opposite party number 5, Manjulata Khanda, comes under the service area of Gaudasai Anganwadi Center. As per the survey list, Anganwadi worker, Tottapada Anganwadi Center, as well as the inquiry report of the Tahsildar Khoira and ADM Baleswar, the appellate authority was convinced that the opposite party number 5 belongs to Gaudasai Anganwadi Center area and that the candidature of opposite party number 5 had been wrongly ignored by the selection committee while selecting the.
What about the petitioner? Whether she belongs to the service area of Gaudasai or not? We are concerned with Gaudasai Anganwadi Center, though.
Thereafter, it has been said the ADM thus found.
No, because OP number 5, the private opposite party's case was not considered.
Sir.
Even though she belongs to a service area.
Yes.
I would like to know whether the petitioner, Santilata Das, or what is your name? Sukantilata Das, whether she belongs to the service area.
Also belongs to that.
If she also belongs, then the selection committee is to consider their
merit otherwise.
Merit. That's all.
Yes.
Unless you can demonstrate that this finding is wrong. But there is nothing against you also in this finding, is it? Alex sir, BY4 देखिए, inquiry report देखिए.
A/4 mind. Comment counter mind.
On verification, the names of the defendant, that is Manjulata Khanda and Bhagwan Parida, was found against serial number 413 and 415 respectively and the Gowda side. Surprisingly, the name of the plaintiff, sorry, say plaintiff defendant the name of plaintiff Sukanti Lata Pradhan and her husband Chittaranjan Prusti was found against serial number 1717 and 718 under Prusti side. The same register prepared in 2002 and signed by DNA to the contrary, surprisingly produced another register. The plaintiff or the, but I mean the Sukanti Lata Pradhan, she also produced a Sukanti Lata Pradhan to me, Sukanti Lata Das.
That's wrongly they are wrong statement.
They produced a register. She produced a register. How? Yes. What is your case, sir? Now tell me.
My lord.
Yes.
My lord, CDPO, as per CDPO inquiry report, they have given the report, my lord.
Where is it? There is some confusion here. Now the new report shows that the private opposite party belongs to Gaudosai. What about the petitioner? I would like to know that. Because the report shows that she belongs to that Prustisai. Whether that Prustisai comes within the service area of Gaudosai Anganwadi Center or not is to be seen. Yes, sir. The only question is whether she belongs to the service area or not. This will serve two purposes.
Yes.
If she belongs to the service area, then the ADM's order has to be complied with. He has only said that a fresh election is to be considered by taking into consideration both the cases and on otherwise whether they are eligible or not.
Eligibility.
And on a comparative assessment of their marks. If she is not a member of the service area, matter ends.
Yes.
Matter ends. So you take that instruction.
So what I am suggesting, my lord, that the ADM may be directed to make a fresh inquiry in that regard and take decision. That is why, my lord.
No, we'll complete it here. Already the matter had come to this court. There was a direction to conduct a fresh inquiry. So cannot cannot multiply litigations.
Here, my lord, there are two reports in favor of the opposition of 5.
You do not know. I do not know. They are relying upon annexure A by 4.
My
That counter. This is an inquiry conducted by the Tahsildar. So it is only for because it says the Sukanti Lata Pradhan. I don't know whether the name is of somebody else or I do not know. Because the name mentioned is Sukanti Lata Pradhan, whereas she is Sukanti Lata Das.
Yes.
Yes. In course of hearing, it is observed that the inquiry report enclosed as annexure A by 4 to the counter filed by the state does not clearly does not indicate the residential status of the petitioner Santilata Das. Though Sukantilata Das, though it is clearly stated that Manjulata Khonda, the opposite party number 5, is a resident of Gaudosai. Let the State Council take specific instructions in this regard. Let this matter on 24th September. In this regard, you listen. If necessary, by filing an affidavit. Let this matter on 24th September. Yes. Yes.
The last occasion, the Lord and additional government advocate filed an additional counter affidavit. And the original counter affidavit was filed by the opener 3 and 4. Again, the additional affidavit is also filed by the Millard. My lord's query that was to be answered by the Lord additional government advocate on my lord's order dated 12/8/2024 that regarding the method of calculation of the special category, that was to be answered. But he has filed a detailed counter. And the annexures marked in the additional affidavit is not in order, not pursuant to the High Court rules, chapter 15, rule 20. On that ground also the additional counter affidavit can be ignored. This is subject to my lord's discretion. But so far the merit of the case, my lords, is concerned, when I take your lordship to the annexure he has relied, annexure B/4 to the additional counter affidavit, my lords, I am placing that, my lord. Subject reserve additional counter affidavit.
Scan
It internal page 19.
On 16/8/2024.
not scanned.
On 20 it was filed.
Then it's 20 ରେ ଆସିଥିଲା ବୋଲି ଦିଆଯାଇଥିଲେ କପିଟା।
ନାଇଁ ଆମର ଏଥିରେ ନାଇଁ ଅଛି ନା ସେଇଟା ଦେଇଦେ। କଣ କରିବ ଏମିତି ଯଦି ସେମାନେ ସ୍କାନିଂ କରିବେ ମେଟା ଡାଟା ତ ଦେବେନି। ମେଟା ଡାଟା ବିଲକୁଲ ଦେଇନି ସେ ବିଲକୁଲ ଜାଣିନାହାନ୍ତି କଣ କରିବ ବନ୍ଦ କରିଦେଲା ହବ ପେପରଲେସଟା ତମେ ବନ୍ଦ କରିଦିଅ। I'll ask the CPC, I'll stop this nonsense. It's going on. ଖୋଜିବାର ଆମର ଯଦି ଟାଇମ୍ ଦେବ yes Mr. ସାହୁ
May I permitted to place me?
କୋଉଟା ଆପଣ କହୁଥିଲେ annexure
B/4 internal page 19.
yes
Subject, this was issued on 5th September 2017.
yes
Reservation and other concessions for the persons with disabilities in various sports of services under state government or public sector undertakings. The government of India have enacted the Rights of Persons and with Disabilities Act 2016 by repealing the Persons with Disabilities Equal Opportunities Protection of Rights and Full Participation Act 1995, which has came into force with effect on 19th April 2017, my lord. This is important. This act came into force with effect on 19 April 2017. My lords, I'm taking on my lord's attention to the on which date the advertisement was made.
କେବେ କହୁନାହାନ୍ତି
When, my lord, the advertisement was made on 26/12/2016. And the categorized post was notified on 17/1/2017.
the date of advertisement
26/12/2016.
yes
And the category wise post notified was made on 17/1/2017.
yes
Therefore, I humbly pray, my lords, this annexure B/4 is not applicable to this case. Now, my lord, I will take your lordships to the impugned page 56 of the writ petition, my lord. My lord, before going to the page 56, I want to submit, my lord, the law decided by the Honorable Apex Court, my lord, in Rajesh Kumar Daria and also the Anil Kumar Gupta, was to be undertaken by the recruiting authority or agency.
Horizontal reservation.
Vertical and horizontal reservation. What to be done while making the selection? When first, as per that judgment, my lord, first select the open competition quota, which is not less than 50% on the basis of merit. Then select each of the vertical reservations quotas, that is SC, ST and SCBC. Third, next to find out how many candidates belonging to special reservations horizontal have been selected on the above basis. Having done so, if the quota fixed for horizontal reservations is already satisfied, no further question of selection arises. If it is not so satisfied, the requisite number of horizontal reservations candidates shall have to be taken and adjusted, accommodated against their respective vertical reservations categories by deleting the corresponding number of candidates therefrom. The process of verification, adjustment, accommodation, and stated above should be applied separately to each of the vertical reservations wherever required. In such a case, the reservation in favor of horizontal categories overall may be satisfied or may not be satisfied. My lord, in the said judgment, my lord, the who are coming under the vertical reservations and who are coming under the
That is not
horizontal
in dispute.
reservation. My lord,
Vertical is the social category, horizontal is the special category.
special category.
Sorry.
Women belonging to
Special category.
my lord, now the exact my case is there. What they have done at page 56. Page 56, they have placed 3 female candidates from serial number 1 to 3. That they cannot do. That is subject to my lord's scrutiny, but this is my submission. The next is my lord's the sports quota, 4-5. 4-5 they cannot do. Total posted 124, 1% is permissible. Therefore, 1 post they can fill from the sports persons quota. But they have done 2 persons in the list. Therefore, 1 should be deleted. The next is, my lord, in social category, they have taken 6, 7, 8, 9, 10. 6, I have no objection. But so far the 7 to 10 is concerned, their names are not found placed in the eligibility list. If they are found in the eligibility list, matter would be different. Where from they got them and how they have entered to this district. Now, well, this is the query to be made. My responsible submission is 1, 2, 3, they cannot place them in serial number 1, 2, 3, the women category. Sports person, only 1 they can do. And PS candidate 7 to 8, they cannot do. This is my case, my lord.
Yes.
Yes, ma'am. My lord, in order to meet the query raised by your lordship, my lord, the present additional affidavit which you have filed, if your lordship come to page number 5, para number 9, my lord. There we have indicated the detailed matter.
Para number 9, they have justified.
Yes.
Which is
May be permitted to place, my lord.
Just a minute. What is his name?
That is important to mention here that during 2016-17, total 989 number of junior teacher contractual posts were advertised for Nabarangpur district, including unfilled vacancies of 2014-15. Out of the total post, 124 posts were meant for category 2 arts, for which the present petitions are concerned. Out of 124 number of posts, 10 number of posts are reserved for the SCBC category. Then, my lord, out of these 10 posts for SCBC category, now, my lord, with respect to 33%, my lord, when there was a requirement to fill up the post from among the women, then 3 number of posts were reserved for the female candidates. And now it has been placed before lordship, my lord, 3 number of female candidates are also indicated in that list, my lord. Then 5 for PH candidates and 2 for sports person. That we have indicated, my lord. Now, your lordship, my lord, on the last occasion, directed me how to reach that particular, how you could reach that particular.
You said that you have carried forward.
With respect to the sports person, my lord, we have stated that 1 post has been carried forward.
Is it permissible?
Now, my lord,
Social category?
yes.
You can carry
Yes,
forward. Special category? I have my doubts.
So, my lord, when this particular post, on-field posts, these are to be placed before the central authority, my lord, at the level of the directorate. So, the Nabarangpur persons, my lord.
The sports category was carried forward.
Yes, ma'am. But with respect to the PH category, my lord,
Yes.
initially it was placed before lordship that it is 3%. But we calculated to be 4%.
That is
On the
wrong
basis-
again, because he has pointed out the dates on which 4% as per the PWD Act.
Yes.
What is it called? PWD Act.
PWD.
My
Act.
lord.
PWD Act. So that comes into effect only from April 2017.
Yes.
Here,
19 April.
here, 19th April. Here, this is a case where the vacancies arose much prior to that.
My
So
lord,
they will be governed by the existing rules unless there is something specifically mentioned that it will be governed by the new rules.
my lord,
Or a corrigendum may have been issued. That has not been issued.
my lord, the resolution which you have followed, my lord, that is of 26/12/2016.
Yes.
And my lord, the advertisement,
Have you said anywhere that because of the PWD Act, you have
yes, we have calculated that 4%, my lord.
No. Advertisement, you please read.
no, in their counter, I want to
the-
ask.
My lord, the first advertisement, my lord, that was issued on
26/12/2016.
26/12/2016,
Yes.
which was later on, my lord, amended to corrigendum, that is on 1/12/2017.
Let us go to that.
It is a
Corrigendum
10 or
on
30
1/12/2017.
10 or 31, my lord,
31 of the?
read petition.
Yes. What does it say?
ଏତଦ୍ୱାରା ସମସ୍ତଙ୍କ ଅବଗତି ନିମନ୍ତେ ଜଣାଇ ଦିଆଯାଉଛି ଓପେପା ଦ୍ୱାରା ପ୍ରକାଶିତ ବିଜ୍ଞାପନ ସଂଖ୍ୟା 26/2016 ରେଖ ଅନୁଯାୟୀ ରାଜ୍ୟର ବିଭିନ୍ନ ରାଜସ୍ୱ ଜିଲ୍ଲାରେ ଥିବା ସରକାରୀ ପ୍ରାଥମିକ ଉଚ୍ଚ ପ୍ରାଥମିକ ବିଦ୍ୟାଳୟରେ ଖାଲି ପଡ଼ିଥିବା ସର୍ବମୋଟ 14,087 ଶିକ୍ଷା ସହାୟିକା ପଦବୀ ପୂରଣ ନିମନ୍ତେ ବିଜ୍ଞାପନ ପ୍ରକାଶ ପାଇଥିଲା। ପରବର୍ତ୍ତୀ ସମୟରେ ମାନ୍ୟବର ଉଚ୍ଚ ନ୍ୟାୟାଳୟ ଓଡ଼ିଶାଙ୍କ WPC number 525 of 2017.
This does not relate to any reservation.
No. This is what, my lord, thereafter, there was a permission to the other candidates even to apply this. My lord.
So this has got nothing to do with the PWD Act. There where the 3% quota was enhanced to 4%. That is not there.
No, but my lord, when the advertisement process was going on and there was a delay in the selection process, my lord, by the time the second advertisement, the second corrigendum actually issued, inviting the application. from the
Even
different eligible
assuming,
candidates.
let us accept it.
Yes, ma'am.
That you could have done it because the selection process was not over. And in the meantime, this new law came, which mandated 4% of
4%, madam.
vacancy. So even if it is 4%, how many posts will be there?
5%.
5 posts. All right. But then
With
you-
respect to one post, regarding the sports quota, madam.
with respect to
With
sports
respect-
quota, yes.
Yes.
That remains.
That is, now it is for your lordship to take a decision, my lord, in that regard. I cannot say, my lord.
No,
but-
what is the law?
My lord, I
assist the court.
I also searched for the same, my lord. But I didn't find that it can be carried forward. But
No.
what they have done, my lord, once they had to place the total number of the vacancies in the revised way, my lord, and it is to be approved by the authority, then this particular categorization has been approved by the authority and accordingly they filled it.
No, Mr. Patnaik, as per my understanding,
Yes, ma'am.
you see, the basic reservation is a social category.
Yes, ma'am.
This special category is dependent on social category. Isn't it? It is a lateral sort of a thing. That is why it is called horizontal. This is called vertical, as per my
Yes,
understanding. So when you have a certain number of posts unfilled and you have another recruitment coming up in the next year or the coming years, so you carry forward the social category, not the special category.
No, my lord, my next answer.
Because that is vacancy based.
Yes, sir. My lord, my next answer will be.
Would you agree with it when I say that special reservations are vacancy based, even though social reservations, social category reservations
post-based.
are post based
Yes.
because of that Nagaraj decision,
Yes, ma'am.
isn't it?
Yes, ma'am.
So that is post based, but this will always be vacancy based.
Vacancy based.
ଏତେ ଜଣ ଅଛି ଏତେ ଜଣରୁ ଏତେଟା ପୋଷ୍ଟ ଅଛି ତା ଭିତରେ ଏତେଟା ଫିଲଅପ ହବ women category ଏତେଟା. This is what I prima facie view. I mean, I don't know.
Now, my lord, this is what, my lord, I placed in para number 9 with respect to the allotment of the different category of the persons. Now, coming to para number 10, my lord, that is only submitted a petitioner was placed in the eligible list of the SCBC social category with a total percentage of mark of 189.4254 and placed at serial number 53 of the eligible list. And there are other 3 candidates of the same category who have secured more mark in comparison to the petitioner. Even if one post which has been filled up in excess by the sports category, my lord. So, my lord, if that particular post is set, filling up that particular post by one ineligible sports category person is there, my lord, then the next meritorious person of the same category, he is to be adjusted, not the petitioner. That is also we have stated. And that it is not on the challenge, my lord. This fact is not on the challenge. And we have named the persons, my lord, and the marks what they have secured in their categories. In the para number 10.
Yes.
So, in order to satisfy lordship's query on the last occasion, my lord.
So what is your
My
reply?
my answer, my lord. My lord,
And I will close it today.
Yes.
well, again, my lords, I am inviting my lords' attention to page 31 of the brief, my lord. ଯେଉଁ second paragraph, ଯେଉଁ ପ୍ରାର୍ଥୀ ଓ ପ୍ରାର୍ଥିନୀ ମାନେ 26/12/2024 ତାରିଖ ବିଜ୍ଞାପନ ଅନୁଯାୟୀ ପୂର୍ବରୁ ଆବେଦନ କରିଛନ୍ତି ସେମାନେ ପୁନର୍ବାର ଆବେଦନ କରିବାର କୌଣସି ଆବଶ୍ୟକତା ନାହିଁ. That means the advertisement was made on 26/12/2016. Next para. ଯେଉଁ ପ୍ରାର୍ଥୀ ଓ ପ୍ରାର୍ଥିନୀ ମାନେ 26/12/2024 ତାରିଖରେ ପ୍ରକାଶିତ ବିଜ୍ଞାପନ ଅନୁସାରେ ଆବଶ୍ୟକ ଯୋଗ୍ୟତା ଥାଇ ମଧ୍ୟ 9/2/2017 ତାରିଖ ସୁଦ୍ଧା ଆବେଦନ କରିନଥିଲେ ସେମାନଙ୍କର ଦରଖାସ୍ତକୁ ବିଚାରକୁ ନିଆଯିବ ନାହିଁ. ନେକ୍ସଟ, ଅନଲାଇନ ମାଧ୍ୟମରେ ଦରଖାସ୍ତ ଗ୍ରହଣ କରିବାର ଶେଷ ତାରିଖ 13/12/2017 କୁ ଧାର୍ଯ୍ୟ କରାଯାଇଛି. This is only extension of time those who have not applied, but the rule was framed on the day the advertisement was made on 26/12/2016. By that time, the amendment rule was not there. So far, it relates to PWD candidates, my lord. My next, my lord, the category-wise vacancy of each category, that is at annexure 6, page 32 of the brief, my lord. This is Nabarangpur district. You are woman, everything is there, my lord.
No, Mr. Rao, he has raised a fundamental question
My lord.
that you have to answer. Supposing whatever you say, even if it is accepted, and this court holds that one person of the sports category has been engaged in excess of the requirement or in excess of the, then whether, supposing he is vacated, this court will say that no, you have wrongly engaged this person. So will it endure to your benefit when he points out that there are 2 more persons who have secured more marks than you?
ଆଜ୍ଞା ସେଇ ଜାଗାକୁ ମୁଁ ଯାଉଛି.
Otherwise, it will be an academic exercise. Why will this court interfere?
ମୁଁ ସେଇ ଯାଉଛି. Additional affidavit ରେ ସେମାନେ ଲେଖିଲେ ପ୍ରଦୀପ କୁମାର ସାମନ୍ତରାୟ, ଶାନ୍ତନୁ କୁମାର ସାମନ୍ତରାୟ, ପ୍ରକାଶ କୁମାର ପ୍ରଧାନ, 3 ଜଣ ମୋଟୁ ହାୟର ସାଇଡ୍ ରେ ମାର୍କ ରଖିଛନ୍ତି. ତାଙ୍କ ସମିଶନ ଏଇଟା. ମାଇ ଲର୍ଡ, ସେଠି ମୁଁ ଖାଲି ଏଲିଜିବିଲିଟି ଲିଷ୍ଟ ପ୍ରକାଶ ପାଇଲା, ତାପରେ ମୁଁ ଗୋଟେ ଅବଜେକ୍ସନ ଦେଲି ଓପେପାରେ ମୁଁ ଅବଜେକ୍ସନ ଦେଲି. ପ୍ରଧାନ ପ୍ରକାଶ କୁମାର ପ୍ରଧାନ ତାଙ୍କ ଆପ୍ଲିକେସନରୁ ମୁଁ ଫାଇଣ୍ଡ ଆଉଟ୍ କଲି ଯେ ସେ ମାତ୍ର 155 ନମ୍ବର ରଖିଛନ୍ତି. କିନ୍ତୁ ଯେତେବେଳେ ଏଲିଜିବିଲିଟି ଲିଷ୍ଟରେ ଓପେପା ଯେତେବେଳେ ପୋଷ୍ଟିଂ କଲା ସାଇଟରେ, ସେତେବେଳେ ତା ନମ୍ବର ବଢିଗଲା ଆପେ ଆପେ 192. That I also objected. Let my learned friend produce that application of that Prakash Kumar Pradhan.
I have filed one affidavit.
The objection is also with me. I
Sir,
can find it by
exactly,
way
my
of
lord. That is what, my lord, I am submitting. If he has any controversy or if he has any
You file an
dispute with
affidavit.
respect to the aberments, my lord, so that he can file an affidavit,
Yes,
so I
yes.
can get it.
Yes, yes.
I do not say.
In course of hearing, responding to paragraph 10 of the additional counter affidavit filed by the state, Sri Sahul and counsel for the petitioner submits that at the relevant time, the petitioner had submitted an objection before the OPEPA authorities
On 15/3/2018.
on 15/3/2018 petition is 155, whereas the marks shown to have been secured by him in the eligibility list is 192.
My lord, exactly.
So it is further
indicated 192.9969.
193.
192.99, he is exactly saying. That is there
192,
also.
yes.
In my objection, that is
Yes.
also there.
192.99,
Yes.
192.9,
9969.
9969. 193 होगा वो कौन?
I
नहीं,
can-
ସେଟା ତାଙ୍କର ତ point ରେ ହିଁ
अच्छा 19. Sri Sahu submits that the objection has not been disposed of. Stop. He wants to file an affidavit in this regard. List this matter next week. Let an affidavit. Let the affidavit. The petitioner may file the affidavit. 17th. Achha. List this matter on 17th September. Affidavit, if any, be filed by the petitioner in the meantime, after serving copy on the state counsel. Thereafter, again, it has to be adjourned because you'll have to take instructions.
in the meantime, my lord,
If you can serve a copy of the affidavit, he'll take instruction.
Advance, my lord, I can.
What I will do is, I will, instead of to 17th, I'll keep it to a little further so that he can also obtain the instructions.
My lord, this copy, Xerox copy.
Not total,
I can-
Xerox.
No, but you have to file an affidavit, no, making specific, taking specific averments so that he can reply to it.
No, by Monday, they will
All
affidavit.
right. Last Sri Sahu undertakes to file such affidavit by Monday. Let a copy of the affidavit so filed, to be filed, be served upon learned state counsel so that he can obtain instructions and file a response
This one.
thereto. List this matter on 17th Porta, 24th September. That will be better.
My lord.
All we are interested is in one post.
Yes.
Yes, also, they cannot
Sorry.
do it.
And in the meantime, both of you, I would request both of you to make some research as to if the social category, special category can be carried forward. I don't think it can be. Because the whole concept is different. Please examine it.
I had consulted with the authorities, my lord.
Hmm.
And ultimately they shifted the responsibility to the DO office, saying that because they had prepared it and accordingly.
Well, the GA department already issued a circular on 19th January 2021 that will brought
Yes,
to my lord's notice in my affidavit. There, what they have stated with regard to the sports category, I am reading that paragraph only. Para 7, reservation for sports persons. As prescribed in resolution number 24808 dated 18/11/1985 and resolution number 33044 dated 11/12/2014, 1% of vacancies arising in a year in each of the categories of Group A, Group B, Group C, Group D posts filled up by direct recruitment shall be reserved for the sports persons. Principle of horizontal reservation shall be followed to fill up these reserved vacancies. In case a SC, ST, SCBC sports person is selected on merit, this will count towards the reservation. This is their circular,
Yes.
recent circular, 19 January.
So the question of carrying forward.
Carry forward is not there. Wrong concept. Totally.
I am also relying upon that circular number 1955 dated 19 January 2021. I am also relying upon this.
So you tell me where does the carry forward concept come?
That is what my lord I told. When I asked them.
Social categories can be.
So actually they shifted the responsibility.
Social categories, this is constitutionally provided.
Now, in one paragraph of their additional counter, they have the opinion 3 and 4 is shifting the responsibility with the opinion 2. The opinion 2 is also a party to this proceeding. He can come forward. He is. I don't know, 15.
Oh, yesterday's matter.
Yesterday's matter.
Same order कर दोगे कल कितने थे RSA 5 of 2024 कल order है ना यहाँ order नहीं थे वो same order
Same.
यहाँ ही
16.
In this case, I have challenged the selection of number 6 as an Anganwadi helper. My main allegation is that.
Mr. Mishra, does the cause of action survive?
Aye.
Survive করছো তো?
Aye.
ঠিক
Because he submitted the forged school living certificate.
Who's for the other side? Prashant Kumar
Only the
Satpathy.
OP number 3, she has filed the affidavit, but the OP number 6, he has admitted on the ground that he has not filed any counter
But there's a counter by OP number 3?
for the CDP.
Yes.
CDP is supporting to the forged certificate, because he has not given any reply to paragraph 7, 8, and 9 of my writ application.
Non-traverse?
Yes.
Non-traverse chalre chalijibo.
And now he the
What is your case, Mr. Mishra?
The case is that, my lord, there was an advertisement for the post of Anganwadi helper. The petitioner and the 6 candidates had applied for that post. Only two candidates, the OP number 6 and the petitioner, they are the widow persons.
Sorry, outside calling?
Yes. The total 7 persons have applied for the post.
Yes.
Out of 7, 2 are absent. Out of 5, the petitioner and OP number 6, they are the widow. The CDPO, he has conducted an Mahila Sabha. In the Mahila Sabha on 24, 2011. But he has not mentioned how many Mahila candidates are attended on that meeting. And for the second, he has taken signature and thumb impression. While I am verifying his counter, it is seen that the OP number 6, he has signed the serial number 57, 58. And one Kamalakanta Mahanti, he has a first page, he has signed, and also his serial number is also 50 in the resolution, with that proceeding. And in the para 7 of their counter, 5 thumb impression are there in the right side. The name is not there and the serial number there. Therefore, they have prepared that resolution and submit the same. And in page 5, see for the moment,
Page 5 of
is the counter. First page, the second page. They have manufactured or he is prepared before that day. What's the last line? Abdek Soika Nimonta Monolita Hele, police posto Huitla Ebong Etire, Boitaka says Karala. In the right side, they have signed the top. And see, they have stopped in the middle of the line and arranged that proceeding. And see the right side, Kamalakanta Mahanti. He has signed. And in the last page, page 7, serial number 50, if the Kamalakanta Mahanti. 2 signatures there, Kamalakanta Mahanti.
There could be another Kamalakanta Mahanti also.
And also serial number 57 and 58. That is Renuka Mula and Renuka Adak, the same person. Page 7, right side.
Yeah, but how can this court arrive at this?
And also, at the bottom, my lords, there are 5 thumb impressions. No name.
So you, when the private opposite party was appointed,
Yes.
Did you raise any objection?
Yes.
Did you challenge it?
That is annexure. They have not taken any decision. That is page 14, annexure 3. The total I have stated in the application.
I think the appeal here lies to the sub-collector.
No, that is Anganwadi helper.
Helper रे भी अच्छी बात है.
No.
पूर्ण नहीं.
Helper no.
25/2007 तो तांको पे लागू नहीं. There is a guideline of 2008.
Helper no.
So let them take a decision. Let them cause an inquiry again. I'll direct the collector.
Yes.
Let a higher authority.
Yes.
No.
Even if
I will direct the collector.
yes. He has given the first certificate mentioning the age in a voter list. For age is 49 years.
All right, I will do one thing. I will permit you to file a representation with your petition being treated as a representation.
Yes.
What do you say?
that would be better, yes.
But he can take the averments, but why the writ petition?
Averments made in the writ application, that will be treated. The averment. Or we'll relegate it to the collector.
Yes.
Let him conduct an inquiry.
Yes.
The petitioner has approached this court with the following prayer. The case of the petitioner, briefly stated is that pursuant to an advertisement issued for engagement of Anganwadi helper, को जगह रे? को center of
Kusida.
Huh?
Kusida.
को जगह लिखा है KUSIDA
Aye.
of Kusida Anganwadi Center, the petitioner and opposite party number 6 were applicants. It is submitted that it is stated that despite both of you belong to the same area,
Yes.
but you secured more marks.
There is no more. There is no question of more. The Mahila Sabha they
Selection.
jaako karibe, selection karibe.
Huh.
But the age is mentioned 18, minimum 18. Above they have not mentioned. But she was 49 years as per the voter list. And my allegation is he is not reading any school, giving a further certificate.
Okay.
And that school also given in the
Correct.
report in the RTI that there is no such record.
According to the guidelines issued by the government, selection of Anganwadi helper was conducted by convening a Mahila Sabha. It is the petitioner's case that despite the fact that the opposite party number 6 was aged more than 49 years at the relevant time and had also submitted false educational certificates, she was selected for engagement. The petitioner submitted a complaint addressed to the CDPO, Bosta, on 31/12/2011. 2010, sorry. However, no action was taken in the matter. Counter-affidavit has been filed justifying the selection of opposite party number 6. A copy of the proceeding of the Mahila Sabha has been enclosed, which contains the signatures / thumb impressions of 60 persons present in the meeting. Stop. Heard Sri J.K. Mishra, learned counsel for the petitioner, and Sri Ardas, learned AGA for the state. Sri Mishra would argue that the fact that the petitioner, that the opposite party number 6 had submitted forged certificates is proved from the information obtained from the concerned school under the RTI Act, which reveals that she was never a student of that institution. Stop. Secondly, Sri Mishra raises serious objections to the proceeding of the Mahila Sabha, enclosed as Annexure A/3 to the counter, on the ground that it contains multiple signatures by the same person, multiple signatures / LTI of the same person, and is apparently manipulated in view of the fact that the last lines of the resolution clearly appear to have been written subsequently. Stop. After hearing
And some thumb impression without any signature.
further, they see sign koriparu no thiyo boli thumb impression kinta naata lekhai reko. Further, some thumb impressions have been affixed without indicating the names of the said persons. Stop. Sri A.R. Das, on the other hand, submits that these are factual aspects which have been duly gone into by the submits that the concerned Mahila Sabha had considered the opposite party number 6 as more suitable than the petitioner, for which she was selected. Stop. After hearing learned counsel for the parties, this court finds that the petitioner had submitted a complaint addressed to the CDPO way back on 31/12/2010. Stop. Same ought to have been considered, comma, if not already considered. That apart, certain objections have been raised with regard to the these are all factual aspects which this court sitting in writ jurisdiction would not like to enter into. Nevertheless, this court finds that the petitioner has a arguable case in her favor. It would therefore be proper if the matter is relooked by the competent authority. Stop. The writ application is therefore disposed of, directing the collector.
Number 2. Copy number 2.
No, collector Balesur
Aye.
to inquire into the matter, particularly in the background of the complaint raised by the petitioner. Stop. The collector shall grant an opportunity of personal hearing to the petitioner, comma, opposite party number 6, as well as other necessary parties, as he may deem fit and proper. Stop. A decision shall be taken basing on the result of the inquiry so conducted by the collector under intimation to all concerned. Stop. The whole exercise should be completed within 2 months from the date of submission of production of certified copy of this order by the petitioner. Stop. The approval Lakhantu. We looking at heard Sri J.K. Mishra, Land Counsel of the petitioner, and Sri Das. Stop. Even though the opposite party number 6 is represented by counsel, comma, there was no appearance despite repeated calls. Stop. This being a case of the year 2011, the matter is therefore taken up for hearing without keeping it pending any further. Yes.
And collector will supply the copy of the final order.
Under intimation to all concerned will likely be.
Item 17.
Item 17, let's see. Can you turn to last order? Say there the ground counsel for the state is directed to produce a document which is very relevant.
I have the instruction that within 2 weeks they can find it out and stop it. On 23rd, your lordship may call it.
Obtain the original letter dated 9/9/1980 of the director for perusal of the court. Parent State Council requests for some time to comply with the previous order on the ground that the necessary documents have not been received as yet. List this matter on 23rd September. 24th September, the previous order be complied with positively.
Great.
Item 18.
Amendment petition of the writ application has been filed.
What amendment?
To be in my writ application as well as prayer.
What amendment?
Actually, in this, actually petitioner, the Vijay Lakshmi Mahandi has filed the writ petition on the death of original writ petition, the husband of Vijay Lakshmi.
You want to amend your prayer? 6. Para 6 and prayer you want to amend? Yes.
Yes.
You have any objection?
That's in which it should say. They made the prayer, your lordship say the amendment schedule.
Yes, that is what I mean.
Party to for a direction to the opposite party to consider the appointment of original writ petition assistant professor. That will be added as treat the
Code लिखा था the petitioner
proposed amendment, page 3 amendment.
by question to original assistant professor by questioning of the original communication, official communication?
Direction, Honorable Court for issuing direction to the opposite party to consider the appointment the original writ petitioner assistant professor. It would have to treat the original petition to have been appointed with promoted to post office with effect on this date.
ଯାହା କରୁଛନ୍ତି ଆଉ କଣ କରିବା
ଆଜ୍ଞା
ଯାହା କରୁଛନ୍ତି କରୁଛନ୍ତି
Okay.
ନା ଆପଣ ଯଦି କରେକ୍ସନ କରିଦେଇ ପାରିବେ କରନ୍ତୁ
କରିଦିଅନ୍ତି
କରିଦେବେ
ସଜେଷ୍ଟ
କରିଦିଅନ୍ତୁ ଏଇଠି ଆଉ କରେକ୍ସନ କରିବେ କଣ
ଆଜ୍ଞା
to treat the appointment of the petitioner as assistant professor
with effect on such and such date.
ଏ ପୁରାଟା ଆଉଥରେ କରିବାକୁ ପଡିବ
ଆଜ୍ଞା
ଏଇଟା ୱିଡ୍ର କରିଦିଅନ୍ତୁ ଫାଇଲ ଅ ବେଟର ଆପ୍ଲିକେସନ ହେଲା
Another amendment.
yes land counsel for the petitioner is permitted to withdraw the IA with liberty to file a better application. Please this matter next week. Better application if any be filed in the meantime.
My appearance will not.
Okay, से ऊपर लिखा हुआ होगा.
The petitioner is paying for rehabilitation as per the government circular as a my lord that is
General Counsel division include the president village education committee hafta bharosa hi hai apne issue notice was issued. What happened?
हाँ my lord हाँ से appear करचंती the president of the VC.
You are appearing? All right. What is your case, Mr. Mantri?
My case is annexure 2 page 15 when the road strength exceeds more than 40. So for engagement of second EV, the district project coordinator, my lord, sent a letter to the BDO Upada endorsing our center, page 15. Page 15, Panabaraja EJ Center, Nilagiri NSC, page 15. 3 number. Again. तापरे annexure 3 रे village education committee जो मैं जी की appointing authority से मैंने resolution कले 2/11/6 रे अद्यता 2/11/6 रेख दिबा 12 घटिका समय रे पानबरज निश्चित शिक्षा केंद्र ग्राम्य शिक्षा कमिटी सभापति श्रीमती निनिमणि सेठी अध्यक्षता रे विद्यालय हता भितर द्वितीय शिक्षयित्री पद सृष्टि निमंते दरखास्त करिवार शेष तारीख 30/10/6 थिला मोट 30/10/6 सुधा 5 जन दरखास्त करथिले दरखास्तकारी के मध्य 1 नंबर संतोषी नंद जानवी बाला राउतुंक नियुक्ति आईन अनुसार 40 वर्ष अतिक्रम करिथिबारु 2 जन दरखास्त ग्राम्य शिक्षा कमिटी सभ्य मान नाकच करथिले पूर्वरु 2 वर्ष धरी बिना वेतन रे द्वितीय शिक्षयित्री भाबे श्रीमती सुजाता जेना पिटिशनर शिक्षादान करुथिबा दृष्टिरु 1 नंबर रखिया पई ग्राम्य शिक्षा कमिटी निष्पत्ति नियागला माइल. So it is signed by all the page 17 president and other members. Thereafter, I was given engagement by the village education committee. Where
is that?
Legendary. attendance register भी देइची annexure.
When were you engaged? No, सेटा काय?
हाँ हाँ सेटा ये जो annexure 13.
Yes. कुमारी सुजाता रानी जेना.
सुजाता रानी जेना.
ମାନେ ସବୁ ଗ୍ରାମ୍ୟ ଶିକ୍ଷା କମିଟିର ନିଷ୍ପତ୍ତି ମୁତାବକ ଆଜି 20/11/2006 ତାରିଖରେ ପାନବରଜ ଉଚ୍ଚ
ଶିକ୍ଷା ନିଯୁକ୍ତି ଦିଆଗଲା.
ଦ୍ୱିତୀୟ ଶିକ୍ଷୟିତ୍ରୀ ଭର୍ତ୍ତି
ଦ୍ୱିତୀୟ ଶିକ୍ଷୟିତ୍ରୀ
ଆଚ୍ଛା ଇଭି ହିସାବରେ ନିଯୁକ୍ତି ଦିଆଗଲା ଗଲା ତାପରେ
ମାଇ ଲର୍ଡ ତାପରେ the problem is I mean why the matter was not considered when other volunteers they are considered for rehabilitation. Why my case was not considered? The village education committee and the DPC, so in between the BRCC was working, block resource center coordinator. ସେମାନେ fees ର documents ଗୁଡାକ ନେଇକି place କରୁଥିଲେ before the DPC. ମାନେ ଏଇଥିରେ ବହୁତ in some other district due to miscommunication the relevant documents were not placed before the DPC for approval. So once they are saying that your engagement is not approved, so there is no question of disengagement. So hence your case was not considered for rehabilitation.
As Gana Shikhyak.
हाँ गण शिक्षक. My thrust of a submission.
So it is the communication is the official management of the BRCC and DPC. So BRCC committed perhaps a mistake in this case. So VC, they have sent the letter, the entire records of the petitioner to the BRCC. BRCC has not, my lord, transmitted to the DPC. As a result, it was not approved. ତେଣୁ ମୁଁ ଯୋଉ attendance register, my engagement and resolution ସବୁଗୁଡାକ it was placed for the BRCC. So presently BRCC ସେ office ତାଙ୍କର merge କରିଗଲା ସବୁ deposit କରିଦେଇଛନ୍ତି before the DPC. Earlier read petition ରେ this honorable court directed the collector to re-inquire the matter. কিন্তু inquiry କଲା ବେଳେ DPC my lord did not provide such documents, entire resolution. The presently I was placing for lordship. So the decision went against me. So presently as the case is primarily established and it is the government ମଧ୍ୟ ଟିକେ ନେଇ ଆସିଲେ relaxation my lord ଗୋଟେ clarificatory instruction ସେଇଟା ବି lordship's clarification. Well, ସେଥିରେ जो माने annexure 6 page 24. Government after careful consideration for the problems of the education volunteers under the education guarantee scheme decided to rehabilitate education volunteers in EJ center who have been disengaged or facing disengagement. So I am coming under the facing disengagement. Properly disengaged calling due to want of records. So my case is under the facing disengagement. One of the case, my lord, decided in this honorable court. If approval later, so it is not the fault of the petitioner constructors. So, her case may be considered by the. ସେଇଟା ହିଁ problem, ସେଇଟା ହିଁ ମୋର ସେଇଥିପାଇଁ ହଉନି ଆମେ ହଉଛି facing disengagement.
Yes, what do you say?
It was reconsidered.
If they reconsider, it would be better.
Where is the order of the collector?
Judgment, my lord. Order of the collector. My lord.
I think annexure 11.
Impugned order, annexure 11, page 37. Shivan Shetty Manuchantivi, last para. A reading of the said resolution makes it clear that those who have been disengaged, facing disengagement of the post of education.
So your case is that these documents, these attendance registers, the resolution of the village education committee and all these things were not produced before the collector.
Yes, ma'am. They were reconsidered in view of the.
Then why should we enter into all these facts? We'll simply say that these documents were not considered. It shall be open to the petitioner, and the petitioner's document may not be considered because the source from which he has obtained may be questioned. But if the concerned village education committee and who's the authority?
Our village education committee, OP number 3.
Village education committee.
Headed by the president. My say resolution.
So you will produce the documents relating to the petitioner? All right. The petitioner has challenged order dated 31/3/2012 passed by the collector Baleswar pursuant to order dated 6/12/2011 of this court in WPC number 31068 of 2011. Sri Mahanti Learned, Sri Subhranshu Mahanti Learned Counsel for the petitioner submits that the order was passed against the petitioner only because the relevant records showing the engagement of petitioner as the second education volunteer of the key center Pannaborojo EVS center, EGS center were not produced before the collector at the time of hearing by the village education committee. Srimanti has referred to, has filed copy of the resolution.
resolution annexer.
6. No,
No, mine annexer three.
3 has filed copy of the resolution dated 2/11/2006 of the Village Education Committee, wherein decision was taken to engage the petitioner as the second education volunteer of the center. Srimati further refers to copy of the order, engagement order, enclosed as Annexure 13 to the rejoinder, whereby the president of the Village Education Committee issued by the Village Education Committee. Stop. According to Srimati, all these documents, as also the copies of the attendance registers showing the work done by the petitioner as the second education volunteer, were never placed before the collector, resulting in the order being passed, resulting in rejection of his claim, her claim. So his lecture, her kar do. Learned counsel appearing for the Village Education Committee fairly submits that the petitioner was, in fact, that as per the records, the petitioner was engaged as the second education volunteer of the center. Stop. He undertakes to produce the relevant documents such as resolution of the Village Education Committee, copy of engagement order issued in favor of the petitioner, attendance registers showing the petitioner's presence in the school, and other relevant documents before the collector, if so directed. Stop. Having regard to the submissions as above, the writ application is allowed. The impugned order under annexure. Having regard to the above submissions, it is clear that the order of the collector was passed without consideration of all the relevant documents, and therefore it is rendered unsustainable. Stop. The writ application is therefore allowed. The impugned order under annexure 11 is hereby quashed. The matter is remanded to the collector to consider the grievance of the petitioner afresh in accordance with law, on the basis of all relevant documents relating to the petitioner's engagement as second education volunteer of the center, to be produced by the president of the Village Education Committee. Stop. The collector shall act upon production of act upon certified copy of this order to be produced by the petitioner, whereupon he shall cause notice to be issued to the concerned Village Education Committee and any other person that he may deem fit and proper. Stop. Further, the collector shall grant opportunity of hearing to all the parties and pass a reasoned order under intimation to the petitioner and all concerned within 2 months thereafter.
Item 20. ସେ ଫୋନଟାକୁ ଉଠେଇବେ କି ଆପ୍ରୁଭ୍ ହେଇନଥିଲା, ଦିସ୍ ଜଜମେଣ୍ଟ ମେ ହେଲ୍ପ ମି, ଯେହେତୁ ଆପ୍ରୁଭ୍ ହେଇନଥିଲା ସେଇଟା ସେ କହିପାରନ୍ତି, ତ ଏଇ ଜଜମେଣ୍ଟରେ I will take the help of.
ଦେଖନ୍ତୁ ଗୋଟେ ଜାଗାରେ ଲେଖିଦିଅନ୍ତୁ, ସେଟା ଆଡ୍ କରିଦେବା. Shri Mahanti further submits that the petitioner's case was also not considered on the ground that
Non-approval.
her engagement was not approved by the appropriate authorities. Stop. However, the matter of approval, matter of grant of approval or otherwise is within the domain of the Village Education Committee and the block education officer
District project coordinator.
and district project coordinator, over which the petitioner has no control. Stop. In this regard, Sri Mahanti has cited a judgment of this court rendered in the case of Sanghamita Patra versus State of Odisha and others, 2013, bracket 1 OLR 941, wherein it was held that for the laches/inaction on the part of the village education committee as well as the other parties in obtaining approval of engagement, the party should not suffer. Stop. Yeah. That's it. Item 20. 20, yes.
And item number 20, my lord. After 3rd of February 2023, this matter has been listed today. And there was a direction to get some instruction, my lord. And we have not-
After we appear करें. Petitioner number 1 is not pressed. None appears for the petitioner on the last occasion. Today also there is no appearance. So why should we keep it pending? None appears for the petitioner on repeated calls. On the last occasion also, there was no appearance. It is therefore presumed that the petitioner is no longer interested to pursue the writ application, which is dismissed for non-prosecution.
Item 21. My lord, I am appearing for CHSE. We filed the counter.
You filed? When did you file?
The registry.
You have served copy?
No, not the
I am
copy.
serving copy now.
Not-
It's not on record. You are the CHSC. You have received copy? Just now?
Just now.
Learned counsel appearing for the CHSC submits that he has filed the counter in the registry. Same be tagged to the case record. Copy of the counter has been served on counsel for the petitioner and the state counsel in court. List this matter.
17 September.
17 September.
Item 22. The sub-item, I am the petitioner.
On behalf of Mr. Mahanti, Aravinda Mahanti, take up next week. By that time, he will file the rejoinder.
And what about your case, Mr. Wali?
In case it is very short question in.
Okay, the time saman matter if he is asking for time, let it come next week. We'll hear it together.
On the last occasion, my lord, I had filed a counter and had solved the copies of the count.
So pleadings are complete.
No,
Rejoinder?
they want.
Doctor, 9 more asking.
All right.
He wants to file the rejoinder.
So next week, huh? All right. As requested on behalf of Sri Aravinda Mahanti, list this matter next week.
Item 23.
Yes. The Tripathi, 23. Item 23.
Counter, Anganwadi case, na? My lord, this matter will be taken 2 weeks after, my lord. In the meantime, we will file the count.
The State Council requests for some time to file counter. List this matter. On 24th September, counter will be filed in the meantime.
Yes, sir. Sorry.
वाला थर से कोई तो फाइल टाइम मिसप्लेस ही चुनी
या मुझे फाइल रिकॉन्स्टिट्यूट कर जम चली थी
item 24
May I please? The petitioners were selected as Sikha sir, and the petitioner challenged the order dated 7/2/2019 under Annexure 9, wherein the case has been rejected that on the ground that the disability has decreased, my lord, is less than 40%. Lordship, kindly have a glance at Annexure 9, that is page 22. Lordship, may come to page 24, the operative part of the order. Both the candidates were selected basing on the disability, that is petitioner number 1, 45% disability, and petitioner number 2, that is 42% disability, my lord. Subsequently, they are asked to reappear before the board, and that has been decreased, my lord. And now they have rejected my case under Annex 9. Lordship, kindly have a glance at the rejoinder I have filed, my lord. Lordship had this matter on last occasion. The page 6, my lord. Rejoinder page 6, my Annex 11. Got it, my lord? My lord, the disability percentage of the Smruti Kona Sarkar, the petitioner number 1, is more than 40%, my lord. She has 40%, 40% permanent disability.
I had asked you to obtain whether petitioner number 2 has any such certificate.
My lord, let her go for re-examination again, my lord, petition number 1 and 2.
Well, so far the action of the authorities is concerned in this case. Well, there is a stipulation in the
40%.
advertisement itself as well as in the resolution that a person who is claiming a benefit under the PS category, after being selected provisionally, they have to be examined once again by the state appellate medical board. Here, after examining in their respective cases before the appellate medical board, they found that one person is below 40%, another person is below 20%. So, there was no occasion for them to.
And the 20% person is petitioner number 2.
2, my lord.
Yeah. I had asked him because he has produced a certificate issued by the central government probably.
Yes, madam.
Whatever that's it.
Page 6.
Disability certificate by the Ministry of.
No, that is the prescribed format, madam.
That is the format. Actually.
It is a format and
it does not bear any signature also.
It
issuing authority, issuing medical authority is there. There is no signature.
Well, let her go for re-examination. But Lordship, kindly have a glance at the.
Unless you show me a prima facie right, how can I? This certificate, where is the original certificate?
My lord, sorry, my lord. Lordship, may kindly come to Annex 10, my lord, of the writ petition, page 25.
Yes.
Page 25, signature is there, my lord. He has 45% temporary in relation to her as per guidelines to be specified, my lord. So her disability is more than 40%, my lord.
How was it certified to be less than 40%? By the appellate medical board?
Yes, madam.
Well, what can be done?
The reports in our counter even.
Yes.
With respect to the persons.
This was issued by the medical authority, but not by the, I don't think this was issued by a board.
And my lord, if
there's a government guideline as to how or who constitutes the board. It is to be by the CDMO and 3 specialists.
Lordship, may come to page number 17 of my counter. Office of the Professor and HOD, Regional Institute of Ophthalmology, SCV Medical College and Hospital. And the persons who were in the board, my lord, they had put their signatures even. And with respect to petitioner, my lord, Smruti Sarkar, visual disability less than 40%. And it is temporary in nature.
But my lord, in the rejoinder which I have given, my lord, it is more than, it is 40% and it is permanent in nature, my lord.
See, key says issuing medical officer of Bhadrak has said, these is the appellate medical board, it prevail karibo.
Well, she is permanently disabled, my lord. Well, if she goes for re-examination also, my lord.
Why? What is wrong in this? You have to challenge this.
Yes,
you have to show that this is wrong. Then only this court can direct.
As per the government regulation, my lord, if it is less than 40%, then she will not be appointed.
No, I'm not saying that.
Yes, my lord.
You come to page 42, running page 42.
Running page?
But of the counter, Annex B by 4 series.
Yes, ma'am.
Where they have enclosed this certificate. The certificate, they have submitted the report, re-examination report of SS candidates of Marubhanj DPC.
Well, page 17. Well, they have only stated is 40, less than 40%.
Yes.
But what is the percentage, my lord?
What about petitioner number 2?
Petitioner number
Petitioner 2, my lord,
well,
second.
that is, my lord, less than 20. My lord, that is admitted, my lord.
My lord, that is at page number.
Page number 20.
20.
Less than 20%.
All right, how do you say that this is wrong?
Well, they have only stated is less than 40%.
So this is vague.
Only less than 40%.
They have to come up with a specific percentage,
Yes, my lord.
because the percentage of disability has to be assessed, not whether it is more than 40 or less than 40. They have not.
Because, my lord, it is with respect to employment, and it is a requirement to either more than 40 or less than 40.
It could be 39% also.
It may be, my lord, but once a person is 39, he is not eligible.
Since there is one certificate, rightly or wrongly, obtained by her, showing that there is 40%, more than 40%, and this does not clearly show anything, this is slightly non-specific, and in her case, a further re-examination can be ordered.
Since my lord, there is also a new certificate to that effect, and that shows that my lord, it is now permanent in nature.
So,
So, your lordship,
but petition number 2?
no.
I have no case.
How kare? Sir, wait.
Huh?
All right. The petitioners have approached this court with the following prayer. Stop. Both the petitioners were applicants for being engaged as Shiksha Sahayak as per advertisement issued on 26/12/2016. Both of them claim to be permanently disabled. Stop. While petitioner number 1, Smrutikana Sarkar, claims to have been disabled to the extent of 45% permanent as per the disability certificate issued by the CDMO Bhadrak. Petitioner number 2, Amita Behra, claims to be disabled to the extent of 42% as per similar certificate issued by the CDMO Bhadrak. As per the provisions, as per the government guidelines, after being placed in the provisional merit list, both the petitioners along with other physically handicapped persons, other disabled persons, physically handicapped persons, other disabled candidates were directed to get themselves examined, were sent for re-examination of their reassessment of their disability by a appellate medical board. Appellate medical board was constituted by the SCB Medical College and Hospital, comprising of 5 doctors. On examination, the petitioner number 1 was found to have disability less than 40%, while petitioner number 2, less than 20%. Insofar as petitioner number 1 is concerned, in addition to the original disability certificate, she also relies upon another certificate issued by the medical authority Bhadrak, wherein her disability is stated to be 45% and permanent in nature. Stop. In contrast, the certificate issued by the appellate medical board does not specify the exact percentage of disability of the petitioner, but has been stated somewhat in general terms that the same is less than 40%. Stop. Stop. On the face of cut off, since there are 2 other certificates showing the disability of the petitioner to be more than 40%, the assessment of disability by the appellate medical board in the manner stated above does not appear to be acceptable. Stop. Considering the above facts, this court is of the considered view that the extent of disability and its nature, either whether permanent or temporary, has to be needs to be reassessed by the appellate medical board after taking into consideration the disability certificates originally issued by the CDMO and subsequently by the medical authority, Bhadrak. Stop. However, insofar as petitioner number 2 is concerned, there is no subsequent certificate showing her disability, showing her, assessing her disability. Stop. Under such circumstances, there is no reason to question the correctness of the assessment made by the appellate medical board. Stop. Para. For the foregoing reasons, therefore, the writ application, insofar as petitioner number 2 is concerned, is dismissed. Insofar as petitioner number 1 is concerned, comma, the same is disposed of with a direction to direction of direction to the state project director. That is, the appellate medical board or party is a party. Direct, and with a direction to the appellate medical board, SCV Medical College, to reassess, to examine and reassess the extent of disability and its nature of the petitioner, and to submit a report to the concerned authority. Stop. The appellate medical board shall act upon a certified copy of this order to be produced by the petitioner. Stop. The assessment and the appellate medical board shall submit its report to
Opposite partner to State
the
Project Director.
State Project Director OPEPA. OSEPA within 4 weeks from the date of production of certified copy by the petitioner. Yes. जी भाई हो जाएगा 24 जाए जी भाई.
Pardon my.
Next item 25. I am applying for the interveners. I have to file only counter. Only 15 days time. My lord, I am. My lord,
Item 20, my lord.
continue.
Item 20, my lord. On behalf of Rajiv Kumar, prefer next week. I got the confusion, my lord.
What confusion? Next week or the item 22. Huh?
Okay.
Next week as paid for. Yes.
Item number 26. May I? The petitioner has challenged the order passed in Anganwadi appeal my lord by the ADM Gajpati my lord, wherein my appointment has been cancelled and the opposite party number 5 has got appointment my lord. The case of the petition is there my lord. My case is there. And an advertisement was published my lord. At the time of selection, there were 6 candidates. 3 candidates did not appear. Thereafter, 3 candidates were in field. Myself, the petitioner, and the opposite party number, and one Sunita Pradhan man. Since opposite party number 5, she doesn't belong to the Anganwadi center area as per the survey report. Her candidature has been rejected. Thereafter, I was the next eligible candidate. I got appointment in the year 2021. Thereafter, opposite party number 5 has challenged, preferred read petition before this Hon'Ble Court, and this Hon'Ble Court has directed to go and file appeal before ADM. Accordingly, she filed appeal, and in appeal, the appellate authority has passed the order without exceeding his jurisdiction. Though my sole stand is that at the time of submission of her application, he did not submit the residential certificate as has been issued by the Tahsildar. But at the time of hearing of the appeal, ADM Gajapati, on being direction of the ADM Gajapati, Tahsildar submitted her residential certificate that she belongs to the Anganwadi center area and in that village. Accordingly, taking into account the report of the Tahsildar, my candidature has been rejected, my appointment has been cancelled, and she has got appointment.
Where's that input order?
My lord, input order. Answer 6. The relevant page, my lord. 35. Relevant portion. May I read, my lord?
Yes.
Being agreed with
সেটা
the
পড়ো খুলে দে তড়ো মানে ইয়ে অপারেটিভ পোর্শনটা
38, my lord. May I read, my lord?
Yes.
In response of order dated 12/10/2022 and 9/11/2020, the CDPO ICD project Nuagada submitted an inquiry report by number such and such dated such and such that the appellant and her family have been enlisted in Betar Singh Anganwadi center area and they are getting social and family benefits from the Betar Singh GP, that is PDS ration. But now the appellant and her family have been enlisted in Concorda Anganwadi Center survey list by house number such and such after selection of Anganwadi worker of Concorda Anganwadi Center. The appellant has not been selected basing on the following reports. 1. Survey list of Concorda Anganwadi Center. Number 2, statement of village committee meeting dated 28/2021 and third, statement of Anganwadi worker Betar Singh. Fourth, statement of concerned lady supervisor of service area of applicant. On observation, it is found that the village Concorda was under R. Udaygiri Tahsil after creation of Nuagad Tahsil on bifurcated from R. Udaygiri Tahsil, it came under Nuagad Tahsil. Village Concorda was under the service area of Moholopada Anganwadi Center ICDS project Nuagad. But the appellant, her family and other 3 householders were enlisted in Betar Singh Anganwadi Center survey list, though all other households of Concorda village were under Moholopada Anganwadi Center. They should have been enlisted in Moholopada Anganwadi Center area and consequently under Concorda Anganwadi Center area after creation of new Anganwadi Center in village Concorda. This improper survey has been caused at the level of ICDS project Nuagad. The Tahsildar Nuagada has rightly issued residence certificate to the applicant being a resident as Concorda village. When the new Anganwadi center was created in Concorda village, the CDP Nuagada ignored the residence certificate issued by the Tahsildar Nuagada to the applicant and rejected her application basing on the improper survey report of Moholopada Anganwadi worker, report of lady supervisor and village committee meeting later such and such. The present Anganwadi worker after due survey has enlisted those 4 houses under Concorda Anganwadi Center service area. In result, the appeal is allowed and the selection committee of the CDPO Nuagada are directed to reconvene and consider the case of present appellant according to procedure laid down by the government with regard to selection of Anganwadi workers so that the case of eligible meritorious candidate will not be overlooked. Thereafter, the CDPO and selection committee have reconvened and my opposite partner 5 has been selected in my place. I have enclosed the appointment order. Next page for page 41 of opposite partner 5. My case before your lordship is that she has not submitted their certificate at the time of submission of her application. Second, my lord, as per the survey report, she belongs to the village of Betar Singh and she does not come under the Concorda Anganwadi Center or Concorda village at the time of selection. Thereafter, he submitted and another survey was made after selection of Anganwadi Center, Anganwadi worker. Another survey was made. In that survey, her name find place. But at the time of selection, her name did not find place.
Yes, state.
Yes, pardon.
May I before state is also platform only for a counter, my lord. State is also, I have not filed rejoinder. I am relying the state counter, my lord.
Paragraph 11.
Paragraph 11, my lord.
Yes,
Page 5, paragraph.
yes.
May I read this? That in reply to the averment made in paragraph 8, it is humbly submitted that the CDPO ICD project Nuagod submitted an inquiry report by number such and stating that the opposite party number 5 and her family have been enlisted in Betar Singh Anganwadi Center area. They are getting social and family benefits from the Betar Singh Gram Panchayat, that is PDS ration. But now the opposite party number 5 and her family have been enlisted in Concord Anganwadi survey list, Bhai House number 30, after selection of Anganwadi worker. Anganwadi worker of Concord Anganwadi. The opposite party number 5 has not been selected on the following list, which has been relied upon by the. In response to order dated the Nuagod Tahsil Nuagod submitted report by number such and along with the report of revenue Betar Singh village statement concordable ration card and voter card of the opposite party reveals that the opposite 5 Srimati Anjali Kaur, the opposite 5 wife person is a foreign. After my selection of the of Anganwadi, that report has been submitted, found that the opposite party of 5 belongs to Anganwadi village or Anganwadi center area.
Yes. Yes, who's appearing for the? Yes.
May I please your lordship, Lord? I have also filed counter to the my humble submission, my lord. Due to erroneous submission of survey report at the time of selection, that was held on 30th October 2021, my lord. Due to wrong survey report. Nonetheless, the present opposite party was enlisted in the survey list of the center area, but she has been meritoriously rejected, though she was meritorious. That so far the merit part is concerned, this election has said that I stood meritorious. But the wrong survey report that was being ramified during the appeal, the inquiry was held by the appellate authority, and from the inquiry, it spilled the beans of the truth that the present opposite party belonged to the center area. And my lord, my humble submission, subject to correct, that the word now in the counter filed by the state, my lord, that has to be understood in the consonance with the bifurcation. That now means, my lord, the bifurcation that held in the year 2017, my lord. Since then, that's why in my counter, I was the status of the present opposite party as belonging to the center area was and is in existence since 2017. So this election held, the first election held in the year 2021. That is after bifurcation. My status was that I belong to the center area. I have just mentioned it. And that was my humble submission that in appeal, the appellate court has relied upon this report and inquiry. That is very important. People lordship to honor the truth, whether at the time of selection I was belonging to the center area or not, keeping in view the bifurcation, that will be probably that is already record in the proceeding. It lordship that my state, because we have not been survived. I participated. He has also participated. That will reveal the truth, Lord. If my status since 17. Only I have been overlooked. That the state has said, only I have been overlooked illegally because of the that is it.
That is what has been stated in the counter-affidavit in support of the appellate order.
Yes. No, but there is some material to show that in the original survey report.
Yes.
And there is also an inquiry report by the CDPO ICDS project on 21/12/2022, which is after the selection.
Yes.
Which says that they have been enlisted in Betar Singh Anganwadi Center area, which is not the concerned center. They are getting social and family benefits from Betar Singh area. But now, opposite party number 5 and her family have enlisted in Concorda AWC. So,
After selection.
So this will mean, ordinarily this would mean that they were residing in another area. After the selection, they have moved on to this place. This could also mean that.
Yes. My submission is 70.
You produce that survey report. Let us see that inquiry report. Do you have a copy of it?
No, at present I don't have.
Then State Council is directed to produce copy of the inquiry report submitted by the CDPO on 21/12/2022 as referred to in paragraph 11 of the counter. Further, he shall also produce the report of the Tahsildar, Nuagada, dated 5/11/2022, referred to in the said paragraph.
And then the proceeding would be better.
The perusal of the court. No, no, let these two things come. Yes.
Although your lordship may direct state council to produce their opposite party number 5 application form along with the document. Whether
And that is not the matter.
whether he has enclosed that document.
He has not said.
No, no, let this be to. The question is who is this president of the service area?
Belong in that.
So that there are two inquiry reports. Let us find out. Let us see that.
My sir, she has not submitted.
Well, that can also be ordered in subsequent stage. Let us see this. Let these documents.
Recently, last week, your lordship has delivered, and since one has did not attach the document at the submission of application ban, that cannot be accepted subsequently. Last occasion, your lordship's judgment in matter of Anganwadi worker. My children let the statement produce.
Where have you taken
order
that?
is sacrosanct.
Have you taken that plea in your?
My lord, kindly see the order dated 3/8/2023.
In appeal, she participated. That question was never raised.
Just a moment.
Order of the coordinator. Paragraph 4. The petition being agreed by merit impugn action of the ADM who has arbitrarily appointed opposite party, despite the fact that opposite party has not submitted the residential certificate before the last date of submission residential certificate for the post of Anganwadi. See further.
The State Council is further directed to produce the copy of the application form submitted by the opposite party number 5, specifically and indicate whether she had submitted any residence certificate along with her application. Yes, list this matter on.
Whether in the appeal he raised that point.
On 1st October.
In appeal he has not raised that point. Your lordship may be.
All right, we'll see this.
First to that.
After any point.
No, not.
Yes.
Item 27.
Your lordship fixed it to
1st October.
The lead case is WPC number 31441 of 2023.
Yes.
Wherein no counter has been filed.
Yes.
And with the other tagged of cases, my lord, that is of 2013 with identical issues. There, my lord, we have already filed a counter. And we may also adopt the same counter, my lord, because it is also relating to the same Kendrapada district, my lord. Only one thing, my lord. In addition to that, I may also pray for 15 days time more in the first case so that it will also cover the other cases to get a response from the opposite partner 1 also.
Right.
Here we have filed a counter on behalf of the BU.
You filed counter in the all the connected case?
All the connected case, madam.
Jason Patak, Learned AG submits that the counter filed in the connected cases, namely the WPC number 21890 of 2013, 21891 of 2013, and 21893 of 2013 shall be adopted for this case. He further needs, he further seeks 15 days time to obtain instructions from the opposite party number 1. Place this matter on 1st October.
Yes. My lord, in this case, my lord, we received a consolidated writ petition on 20th August, my lord.
Last order.
Yes. And we have received the all original documents, my lord. So
last time also you took the same ground.
Odia ନେଇଥିଲୁ ଦେଇଛୁ ତାଙ୍କ ପାଖରୁ କିଛି response ଆସି on 20th August.
1 week time. As requested by Learned State Council, 1 week time is allowed to file counter. List this matter. Go to week 17th September. Yes.
29. Item number 29, my lord. I am representing opposite party number 2. Last time, my lord, I had made a submission that the CDMO has been authorized to file the counter. But in the meantime, the writ application is amended and a consolidated writ petition has been filed
wherein the opposite party number 2 order has now been under challenge. So I'll file a counter, my lord, because my order is under challenge.
Your lordship kindly fix this order, because they have already taken total.
The mission director's order is now under challenge under Annexure 8, which was not there earlier in the writ application.
All right. Shri Vibhu Prasad Tripathi, Learned Counsel appearing for the opposite parties. Requests for some time to file the counter. As in the meantime, the writ application has been amended. Stop. List this matter. On 24th September, counter affidavit will be filed positively in the meantime.
Deeply grateful.
Therefore, Mr. Behera, the matter has become in process.
Dismissed as influxure.
31.
May I please, Your Lordship. Petitioner is praying for transfer of the case from the Court of Civil Judge Senior Division Chhatrapur to Family Court Deccan. The petitioner's case in brief is that petitioner is working as a constable and presently posted at Anganwadi. And her husband is the inspector and he is posted at PS MB 79 Malkangiri. The husband has filed this for a divorce before the learned Civil Judge Senior Division Chhatrapur. But all the witnesses that are going to lead evidence, they, on behalf of the petitioner, they are at present residing at Deccan. And further, my lord, there is threat to her life. Because earlier there was a dispute between the husband and wife, and the matter has been lost before the.
She is herself a police woman. What threat to life?
Constable say Inspector Hegel or superior.
Threat or perception depending on the rank or what?
Yes, he has to travel.
Who's appearing for the other side? Who's for the other side?
Nobody has appeared. Since last 2 dates, nobody is appearing.
Notice in the admission stay matter issued to Solo P by school post 80. Courts order right there. Issued on to necessary action.
Notice is served at the police station. The
item has been delivered.
Yes, my lord. The constable who was in sentry duty has received the article. Well, another important thing is, my lord, the 2 minor childs are with the petitioner.
That's true.
So traveling a distance of 400 kilometers to and fro will be difficult.
Notice on opposite party appears to have been served. Office not opposite. This is item 31. No? AD returned from sole opposite party with the signature of one Basanti Rai. Constable 202. Relationship not mentioned. Take fresh notice.
Well, I have verified she was in the sentry duty in the police station. Notice was
No,
issued to the
no,
police
no,
station.
no, you take it. She's in which police? He is in which police station?
MB 79 Malkangiri.
As inspector.
Hello?
As the inspector.
Sub inspector.
As the sub inspector. So there must be an IAC of that police station.
Fine.
Or officer in charge, whoever. So we will direct the state. You cause personal service on him.
Yes.
Hmm.
Yes, I have the number of IAC, MB 70.
Let fresh notice be issued to the opposite party.
Copy
Learned counsel for the petitioner is directed to serve a copy of the transfer petition on the state council, who shall cause the same to be personally served on the opposite party through the IAC of the concerned police station, indicating that the matter shall be taken up for hearing on
24th September.
24th September. Now we stay there. Yes.
Obliged.
Item 32.
Mr. Potti, I may be permitted to place this.
Let us see what has happened to the notice.
Last, lordship directed to State Council.
Yes, already received the notice on 38/2024. Tirisat.
Then State Council informs that.
I am echoing the budget party.
Yes. Sri Kirtan Dank, advocate, enters appearance for the opposite party by filing wakalatnama file by filing wakalatnama the same be kept on record. You want it to be transferred from which place to which place?
From Raulkela, Lord and George Family Court, Raulkela to Balangir.
Raulkela to Balangir.
In the ground that, my lord.
Any chance of settlement?
No, there is. My lords, with the people lordship, kindly go to the annexure, my lord. Twice I have lost the affair. Husband took me with him, then tortured me. Then when I have filed a DB case against him, he was appeared there at Balangir and said that there is a decree of divorce already passed. Expedited decree was passed.
So now?
Then I have appeared at Raulkela and filed a expedited petition, setting aside expedited petition and along with delay condonation of delay. I seek for transfer of that petition along with divorce petition to the.
Yes. What is
my
it?
lord, so the opposite party only supply for me Bhina matter 2D, my lords. Let's matter 1 week after.
All right. Grant 1 week time. As requested by Sri Dang, list this matter on 17th September.
Item 33.
Your Lordship, this is a case of transfer petition from SDJM Raulkela to Bhubaneswar. On the last occasion, Your Lordship had stated that last opportunity be given to the opposite party to appear today.
Yes. Anybody appearing today? All right. Want it to be transferred from?
Your Lordship, from SDJM Raulkela to SDJM Bhubaneswar.
What is this matter?
Your Lordship, this is a DV case filed by the opposite party. The petitioner is the father-in-law of the opposite party, and the opposite party has already filed 3 cases at Family Court Bhubaneswar. The petitioner's son had initially filed a divorce proceeding, which was transferred to Family Court Bhubaneswar on the insistence of the opposite party. Then she had also filed an application for maintenance, and now currently that is on the execution stage. So now her filing a DB case at Raulkela is nothing but a harassing tactic to the petitioner.
No, but she being a lady, it will be more difficult for her to, if she is residing according to you at Bhubaneswar, why will she file a case at Raulkela? It will be more inconvenient to her.
Yes, Your Lordship, she has exactly, this is my point, that she had filed a DB case at Raulkela, whereas already she is fighting 3 cases at Bhubaneswar.
No. She is also required to attend that case. The case which she has filed at Raulkela, she has to attend that case. So go against her own interest, why will she file a case only to harass you?
But Lordship, when she is fighting 3 cases at
So
Bhubaneswar
what?
already.
There may be n number of cases. Anyway, that is not a ground for transfer. The convenience of the parties, particularly of the lady, has to be seen.
Petitioner is an elderly man and traveling from Bhubaneswar.
What elderly
to
man?
Raulkela,
Nothing.
500 kilometers overnight.
67 years, what elderly man? Nothing. I don't find any ground to transfer. The lady will be unnecessarily subjected to. And
Your Lordship may adjourn for another.
well, why? You are arguing? Why should I argue it? Yes. You know, the art of learning advocacy is the art of learning how to lose cases. Rather than winning cases, you must learn how to lose cases. Why are you worried about it? Why are you worried about the result of your case? You place your whatever matters are there. Try to justify.
If she was very convenient to attend the cases, why did she first transfer the initial divorce proceeding from which was filed by the petitioner's son at Raulkela, but she transferred it?
Doesn't matter at all. We are concerned only with this case. For this case, she has filed it at Raulkela. She'll have to attend every day on each date of posting. So she has to take she has to travel from Bhubaneswar to Raulkela on each date of posting of the case. So why?
But Your Lordship, she has filed this case after 10 years of separation.
Maybe that's a different matter. That is on merits. Whatever you may have a ground to challenge the on merits. How will you? Had she appeared, then it would have been a different matter. But since she chose not to appear. What are the status of the cases that have been filed by her according to you at the Bhubaneswar? Different
Your
courts of.
Lordship, the divorce proceeding is currently pending. The maintenance has been.
No, pending. What stage?
Your Lordship, I'm not currently.
Right. Learned counsel for the petitioner is directed to furnish the status of all the cases filed by the opposite party wife, opposite party, said to be pending before different courts at Bhubaneswar. Please this matter.
17 September.
Grateful, Your Lordship.
Item 34.
My lord, I am appearing for opposite party.
My lord, in this case, I am for the petition.
ଆପଣ ସେଠି କାହିଁ ବସିଛନ୍ତି ମିଷ୍ଟର ଦାସ? ଆପଣ ସେ ଜାଗା ନୁହେଁ ଆପଣ. That is for the arguing counsel.
3 weeks time,
Huh.
lordship may grant 3 weeks time to file objection, my lord, in this.
3 weeks time for objection. Why? Why?
And there is no record.
Yes. No chance of settlement.
My lord, no, my lord. Already divorce allowed, my lord.
Achha.
Divorce allowed, and in annexure 1 series, my lord, kindly glance the page number 23, your lordship. The present opposite party has filed a DB case from family judge Bankanal to family judge Jajpur, my lord. During that period, my lord, the Krishnapriya Ratha and Radheshyam Panda both are residing at Hyderabad, my lord. They both are employed at Hyderabad, my lord.
All right, he wants to file an objection. I'll grant him some time.
My lord.
Then counsel for the opposite party wants to file objection to the transfer application and seeks time for such purpose. Place this matter on 24th September. Interim order to continue.
Oblige, Lord.
Item 35.
Yes, item 38. Yes, Mr. Das.
Two cases are there. In
Two
one
cases.
case, I am for the opposite party. In one case, my senior is appearing on behalf of the petitioner towards opposite party.
Yes. So you are appearing for there are two ladies.
Two ladies, my lord.
For mother-in-law.
Your lordship had sent it to mediation.
Mediation has been.
Mediation failed because of the arrogancy of the boy, my lord.
No.
He does not want to take. I was present in the mediation. So he does not want my company in any way. So, my lord, this is how the thing stands and the report must have come.
So you are appearing for Sudeshna Mahapatra.
Sudeshna.
And you are appearing for
Anita Pani.
Anita Pani.
who is how are they related?
Sasu.
Mother-in-law.
Sasu is my Sasu.
Okay. Where is the case pending now?
Rairangpur.
Right.
I am residing at Hon'Ble. They have appeared. The informant appeared. The present opposite party who is appearing, my lord. She has appeared before the Hon'Ble and filed the WS in the another case, my lord. My humble submission before lordship, my lord and senior has said so that due to arrogancy, a case has been instituted somehow or other that has been pending before the London court below 198 along with other offences. Both were software engineers. To my instruction, the opposite party, now she has been residing at Bhubaneswar. And another thing, my lord, the present petition also working as a software engineer. I am fairly submitting before lordship. In company, my lord, if any criminal case has been instituted, if any information has been given anybody else, then he will be terminated forthwith. Now, the son of the present petitioner is nowhere because he has already been terminated. So he was residing with his parents. My humble submission before your lordship, many cases have been instituted by the present opposite party at Rairangpur. Even though accepting for a moment, that is altogether different story, cause of action, other things that is not within the territorial jurisdiction of Rairangpur. I have to travel from Hon'Ble to Cuttack, Cuttack to Rairangpur. And more particularly, my lord, even though accepting for a moment in DV proceeding, various judgments are there. The agreed party initiated proceeding against the male, not female person. She has any claim against the husband. Because in Domestic Violence Act, under section 12 of the Domestic Violence Act, she has to sort for monetary relief from the husband. Anything she has claimed from the husband. I have been unnecessarily party in that proceeding. And the petitioner is suffering from various elements, old age element, my lord. My lord, your lordship may can see the age of the petitioner, 51 years, my lord. That is a case of quashing, that is altogether different story. That is the law has been laid down by this honorable court, my lord judge. If you have any grievance against the person concerned, then you can be necessary party, the husband is the necessary party. Entire family member, they have been robbed, my lord, in DV proceeding. What they will do? If you have any claim, as per the statutory provision of laws, section 12 of the Domestic Violence Act, then it is against the husband, my lord. And while she has appeared in the second case, my lord, at Hon'Ble.
So where is it pending?
That is pending before the SDM Rairangpur, my lord.
But in
Annexure
your
1,
case,
page 12.
no, but Mr. Sarangi, in your case, the prayer is to transfer it from family court Hon'Ble to civil to Rairangpur.
Second case. Second matter has come.
Yeah, yeah.
I have prayed before your lordship, for that reason, this matter has been.
Should I submit your lordship?
Let him, are you done? Have you completed?
Right.
All right, then Mr.
51 years age, my lord, is no age these days. In any case, my lord, she is an author of repute. She moves around the entire state, maybe the country as an author. She speaks a lot. So the movement is not the restricted. My question is, my lord, mediation has failed. Neither any money was offered. But since the mediation has failed, just a moment. Mediation failed. If he is so conscious, so he should have taken steps to, my lord, take me back at least because I am interested. It is right, software engineers, but I am working from home from at this place, my lord, Rairangpur. My father is there. Bhubaneswar is absolutely falsehood, my lord. Father is there employed as a doctor that can be verified from any sources, my lord.
Yeah.
And he is still employed. It is not wrong.
If you both agree, we can have it at a neutral place.
My lord, Messi, I have already initiated some other cases. There are city case pending there in Rairangpur, 498 and others. So also CMC 302 for maintenance. And my lord, that is against husband, his right. And my lord, apart from this, I am seeking transfer of this from Hon'Ble to this divorce case which my husband has filed to that matter is pending in the second case to Rairangpur.
Then who's appearing in that case?
I am appearing. And
No, who's appearing for the opposite party in that
he is
case?
appearing.
For the husband also.
He is appearing there.
In one case, my senior is petitioner. I am for the opposite.
Second case, I am
In
petitioner.
case-
And the second case, your lordship had sent to mediation. So now they have appeared in this case in Rairangpur and have already filed counter. If they say that it is not maintainable against the mother-in-law because they seek to transfer it from Rairangpur to Rairangpur to Hon'Ble, my lord, let them file appropriate petition before the trial court.
Then that is a different matter. Let them
And
file.
others are also there. Other cases are there. They're fighting. They're contesting. They're already there in the Rairangpur courts. And my appearance, as he says, in this case, no, your lordship has stayed that matter. I have not appeared in Hon'Ble court.
Can I produce before your lordship what my senior saying so that from the order sheet cannot tell a lie because it is a judicial order. They have appeared. She has appeared. Filed the WS. Another thing.
In the marriage case? No, in the marriage case.
In that case, which I have initiated at the Hon'Ble, she has appeared, filed the WS. The case which has been instituted at the behest of my daughter-in-law at Rairangpur, we have never appeared. In case of 498A, we have got that bail, my lord. Entire family member, they have been robbed in that.
Counter to the look.
All right. So let us close it.
This is counter I am holding. In the Rairangpur case.
Anyway, I'm closing it. All right. Hearing concluded, judgment reserved.
Obliged.
Item 36.
Pardon your lordship, in item 33, an interim order was there. You may kindly give direction to.
Which one?
Item 33, an interim order was continuing till date.
Can I pray? On last occasion, my senior has saying so that date has been fixed to give my senior be directed to not to take any coercive steps against the.
What coercive?
Because you have to pray that BW or NBW.
Judgment has been reserved.
That is true.
No coercive action shall be taken against any of the parties till pronouncement of judgment.
And in that case, your lordship, she is not the only party.
I said any of the parties.
Any of the party.
till the pronouncement of judgment.
Oblige.
Your Lordship, in item 33, interim order was
I've
conducted.
already passed that.
Grateful.
Item 36, petitioner is the wife, my lord, seeks to refer transfer of the CP number in Judge Family Court Kotak to Fulbani, my lord. On the ground that there is old parents, my lord, living with the petitioner, my lord, and the distance is, my lord, to far, my lord, around 300 kilometers more than.
Was it sent for mediation?
Mediation, my lord, the wife, husband is neither interested to go to mediation center or Fulbani, nor my lord, he is paying to transporting cost as per my lord, 13(8) non-24 order, my lord.
May I please allow?
13(8).
On that, they all, my lord, the husband also not interested to pay beyond the transportation cost, my lord. The expert, my lord, medicine was not sent for them.
May I please allow?
Tirunelveli. Yes.
Milord, on last occasion, the advocate for the petitioner undertook to make the necessary adulterer as a necessary party in this proceeding first. But they told that they will file the amendment petition, and till now I have not received.
I have filed the IA, my lord.
I have not received the copy to that effect.
I have filed the IA.
And
there is no IA. IA kete?
I'll take you, my lord.
Original.
Where is the IA?
48 filings.
IA number kete? Release this matter day after tomorrow along with IA said to have been filed by the petitioner on 28th 2024 with prayer to implead a party. Yes.
Copy kindly provide.
A copy of the IAB is served upon learned counsel for the other side.
Deeply.
Item 37. May I please move it?
Yes, state.
My lord.
Notice has been served.
Notice, my lord, your lordship, see the cause title my learned friend has put, my lord. He has written that at present care of Power House Colony, Jaipur, District Koraput. So I have taken instruction from the town PS Koraput, Jaipur, that no one is residing as Ashish Kumar's house and a permanent so. Yes, the IAC has taken instruction from that ward, councillor of that ward, my lord. Then
Pardon, kindly say Annex 3, page 47.
Annex 3 or cost title I'm dekho,
Annex 3, page 47. In CP number 33 of 2023, the husband has given this address. And
say
also,
address
that address I have given, which address he has furnished before the Learned Judge Family Court Jaipur. Another interesting thing, my lord. While he was contesting at Malkanigiri, another address was there. I pray, my lord, throw court, throw court. I mean, pardon, my kindly have a glance to page 29.
Yeah, go to Learned State Council informs that notice could not be served on the opposite party as the IIC has reported that there is no person by the name of Ashish Kumar Sahu residing in the address mentioned in the transfer application.
Present address, at present due to election.
However, Sri Ponda, Learned Counsel for the petitioner, referring to the divorce petition filed by the opposite party husband in the court below, submits that the address is the same as was given by the petitioner, as was given by the husband himself in the said application. In such view of the matter, let notice be issued through the court process, requisites for which shall be filed within 3 working days. Notice be served upon the opposite party, making it returnable within 3 weeks. List this matter on
8th October.
8th October.
Interim order
to continue.
I mean, pardon. If possible through court.
I said for service of notice through the court process, right?
Pardon, intermediate court.
Item
Intermediate
38.
court.
I have appeared for the opposite party.
Yes.
Notice was served to my one of my relative because I was not
Relative and this time father of the petitioner.
father of the
Also,
petitioner because I was out of with my mother for ailing mother. So I have not received the copy of the.
The father of the petitioner.
Today I have received the copy from my learned friend, and let it come after 2 weeks. or 5.
No. After, I'm grateful to your lordship due to the a great effort while lordship through my learned brother through police very difficulty with much difficulty they have received copy in
They were ailing, both parents ailing, not staying here, and that petitioner is
however,
staying at
my
Bangalore.
learned senior just before 1 hour he was suggesting me that the matter should be sent to the mediation center.
That may be chance of
That I have no objection. But without saying this thing, he's asking
No,
time.
copy ଟା ଦେଖିନି।
ମୁଁ କପି ତ କଣ କପି
ଦେଲା।
ଟ୍ରାନ୍ସପୋର୍ଟ ହବ ବୋଲି ଦିଆହେଇଛି ଓକେ।
In course of hearing, both parties submit that there is a possibility of amicable resolution of the dispute. Hence, that the records be placed before the coordinator Odisha High Court Mediation Center. Is this matter on
29th October.
29th October?
Yes, sir. Item 39.
My lord, I on behalf of the opposite party for learned counsel Sri Om Swarup. My lord, sir is suffering from high fever, so I'm seeking 2 days adjournment, my lord.
Next question. As requested by Lawrence.
फोन भी करथिले ज्वर ପାଇଁ ଖାଲି ପରଦିନ କହୁଥିଲେ ସୋମବାର ଗୋଟେ ହଉନ
No, so Mangalwar. As requested by learned counsel for the opposite party, list this matter on 10th September.
Objection.
Item number 40.
Immediately, I filed the requisite matter. Flag B, my lord, postal tracking report.
Confirms the service of notice. As per the postal tracking report, notice on the opposite party was served on 31/8/2024. There is no appearance today. Since notice was served recently, one more opportunity is granted to the opposite party to appear. List this matter on 17th September. Interim order to continue.
Item 41.
May I please? Last occasion notice was issued. Last
Yes.
occasion notice was issued to the opposite party. The address which has given to the CP number 521/2024. But subsequently she has not.
Since notice could not be served, let fresh notice be issued by both ways. That is the registered post as also through the court. Requisites be filed within 3 working days. List this the short returnable date be fixed. List this matter on 22nd October.
Interim order.
Interim order to continue.
Objection.
Item 42.
Yes. This is a case on section 341/23/302/35. Here, the allegation against the accused constitute 18/12/21. But the statement of the, I think the 9 witnesses have already been examined. The statement of the informant that there is a family dispute between them. Prior to that, there is no intention for killing. As so far as my present petition is concerned, there is an allegation of the PW1 statement that records Counter. The statement is there.
What is your name?
My name is Badal.
Rakesh Naik,
Rakesh Naik,
alias Badal.
alias Badal.
Rakesh Naik.
alias Badal.
Earlier rejected.
Yes, that is correct. Here, the assault allegation of the
Direct
father-
allegation.
No, it's not direct allegation. That's right. I'll show that.
the other, it is an admitted fact that there is a family dispute and everything. The other of the petitioner assaulted the deceased head. So there's some statement, there's some policy statement.
I had heard this matter.
Yes, also had this matter.
I was not inclined. I was not inclined.
No, so set up time.
And another eyewitness also one.
Time I was not inclined. Sitting करथिली list when moved.
Yes.
तापर आपण move करी ताको list करी.
Sorry, is kind of statement देखो sir. Informant को सुनती.
देखो ना तब statement देखो मुझको मना
नहीं
करते.
सर statement ये ना साथ कौन सी मुझे देखो सर.
ओ देखा.
सर informant के साथ कोई ले कोई चीज़ बापा पत्थरे मुंडो को.
नहीं interpret करो तुरी पढ़ो तो कोई जगह नहीं सीधा करो.
Statement the Pedal one. But I am the informant in this case. The deceased Jagannath Naik was my husband. I know all the three accused persons standing inside the dock. They are Rathia, Badal, and Alina.
You are Badal.
Is Badal. The occurrence took place about 1 year 8 months back in front of our house. On the day of occurrence, at about 7 a.m., there was a disturbance between my deceased husband and the deceased accused persons and their family members, Basanti Naik and Barsa Naik, relating to land matters. On my interference, the matter subsided. Then my husband went for his work. At 5 p.m., that my husband returned from his work and inquired about the accused persons as to why they stopped putting enclosure between our lands in which accused Rathia assaulted father of the informant. This petition number. Accused Rathia assaulted to the head of my husband twice with a lathi and accused Badal assaulted to the head of my husband by a farsa. And accused Alina assaulted him to his chest with his silupia. Basanti and Barsa gave kicks to my husband. On my interference, I was also assaulted by them. My husband fell down, being assaulted, and the accused person fled away from the spot. This is similar. Then there's the cross-examination. Cross-examination for the para forest legacy. It is a fact that occurrence took place due to land dispute. The occurrence took place just in front of my house. The house of the deceased accused persons is adjacent to our house. No outsiders were present at the time of occurrence that took place at 5 p.m. My Vasudha Naik was present at that time. It is a fact that there was a quarrel between my husband and the accused persons prior to assault on my husband. There was no dispute between my husband and the accused person prior to day of occurrence. It is not a fact that I have not stated before the police that accused Rathia gave 2 blows to the head of my husband with a lathi, and Basanti Barsa assaulted him by kicks, and that my Dedusra and father-in-law being informed came and shifted my husband, injured husband, to the hospital. I was examined by police on 2 occasions, but I cannot say when I was examined on the second occasion. It is not a fact that I am not an eyewitness to the occurrence. This statement of the prosecution said that question was put that they say answered that came the my this present petitioner. That is not that part is not there.
What is not there?
से भूल कर सिंधी ट्रायल करना तो को
नहीं नहीं से तो क्या उन्होंने सेटा हमें किंतु होल्ड करें
page of 5
सुनो and accused Badal assaulted to the head of my husband by a farsa.
Yes, that part say farsa का तो coach that time मुझे आनी चाहिए सर exam certificate copy आनी चाहिए तारो injury report मुझे देखिए सर then last time का से page 5 step page 5 the husband of the informant
PW3 is
yes, 3 is
PW3.
3 is not so important. Yes, I'm reading that.
Accused Rathia was holding a stick and Badal was holding a farsa. They assaulted the deceased to his head, and the deceased sustained bleeding injury.
Yes. What is that? Then the PW 5 is important. PW 5 that will show that what type of injury has how the present petition is involved, and what is the condition of the deceased when he died. That is PW 5 is eyewitness to the.
Thereafter, his son Badal Naik assaulted my younger brother with a farsa, and my brother fell down on the ground. Consistently, everybody says that you have.
And yes, that is that.
One vital witness, Pradeep Naik is
PW 5
Pradeep Kumar Sethi.
Yes, PW 5. PW 5.
PW 5 पढ़ली पे बड़ा घर नायक.
PW yes, PW 5 जैसा पढ़ूँ.
पूरा पढ़े दरकार नहीं.
Thereafter, sir, the injured है. Accused is the बापा ये head को बढ़ाई सी ठीक है ची. ये क्वेश्चन दी फारसा आनला देन लक्ष्मी द नेचर ऑफ इंजुरी से कौन से प्रोसीजर से पढ़ू से प्रोसीजर कौन देसी सर दैट इज वेरी इंपोर्टेंट सर दुई सर द नेचर ऑफ इंजुरी और कौन से द कंडीशन ऑफ द अक्यूज डिसीज दैट हाउ इट इज ट्रू दैट विल सी दैट It is a fact that I cannot say the contents of exhibit P2, P1. I was at Deccanal when my wife informed me of the occurrence over phone. The distance between our village and Deccanal is about 12 kilometers. I received the phone call from my wife at about 6:30 p.m. on the day of occurrence. I reached home with 7 p.m. that day. I brought the injured to Deccanal hospital in my scooty. Very important. On scooter, disease vasigala. That's it. Scooty. Then injured sat on my scooty holding me. We reached Deccanal hospital at about 7 p.m. I was bringing back the injured from the hospital after the treatment of the OPD. Return. The place where the injured complained of chest pain is at distance about 4 to 5 p.m. from Deccanal. It was then about 8 p.m. It is a fact that the injured has not stated me anything in between Deccanal and the spot where the complaint of the chest pain. Police had not seized any wearing apparatus of which I had owned while taking the injured to the hospital. When I returned to home, getting information from my wife, I found the injured lying near the outer ports of my house. The police arrived at the hospital after the injured declared dead and was still in the hospital. The informant was then present there. From the medical, I returned home. The informant also returned home from the medical. Thereafter, I have not gone to the police station in connection with the case. The police examined me in this case after 5 to 6 days of the occurrence. It is a fact that the injured was senseless when I reached there. It is not a fact that I have not studied for the police and so. So very important. Sir, deceased को नेला scooter से बसी गला. से कौन से head injury जो where से तब allegation कराई थी. बापा head injury माइला ये फार्सन हानिला. किंतु deceased तक scooter बसी hospital गला. OPD आसिला. This is the allegation. तापर से कौन से injury से कौन है जी ना मोर chest pain हैला. Chest pain से मरी गला. So where is injury? Then last month the injury report से आंटी. Injury reports are कौन nature of injuries are कौन है?
Injury report or postmortem report?
Sorry, postmortem report sir.
Cardiocerebral injury.
कौन सा injuries they said the above injuries are antemortem in nature would have caused due to hard and blunt screws in respect and the fixation rough steps. So the cut injuries is not. So far as the first size concerned, cut injuries is not there. Yes, court is not there. So he has been brought to the case. Instead is there. What allegation is ठीक but what is the allegation against the petition that is not specified that. That I have got the original. I have taken that.
External injury 1.
Yes.
Bleeding present in right ear.
Yes, that is there.
Abraded contusion present
yes.
On the forehead of size so and so.
Yes.
Abraded contusion of side present over right temporal area of size of size of right shoulder.
Sir, so farsa कुछ use करी सी, पर जो मुंडो बाड़ी chest pain होती मरी गया.
Contusion डाची बरे?
Sir?
Contusion होती हो?
नहीं sir ठीक सर मुझे जो farsa देखो सी, पापा जोड़े दी थर तक twice ता मुंडो बाड़ेला, वो तार बहुनी छाती के माइला पत्थर रे, ये माइला farsa. So Lakshmi can imagine. I don't say the Lakshmi what the order pass blood, but Lakshmi is how my client is brought to the case. Man said farsa hanuchi, वो लोग पंची जाऊँची आसुची, तबरे पांचटा सकाल रात्रि हैला, पांचटा PM में मरे गया. So गोटे farsa में 3 4 जन मारुचंदी से एते सम पंची. This is the Lakshmi can visualize the situation of my client.
No. Unless you say that this postmortem report has been falsely prepared by the doctor, then you have no case.
This is report. This is report.
You have absolutely no case.
Yes. But this is report, Lakshmi. But sir, this is
a direct allegation.
These are acquisition.
It's a direct allegation and direct allegation being spoken by the ocular evidence.
It's a statement the Peter.
Wait. And this postmortem report doesn't help you, rather helps the prosecution.
Sir, Sir, that's fine. These are acquisition is my custody, my client is custody. Papa,
so conviction only जीवन सारा रहेगा.
Sir, nice. But sir, ये जो case है, Lakshmi say that the pedal fives evidence is completely shows that the nature of injury, nature of acquisition of my client. But pedal five clear. But sir, this is केवल sir scooter रे बसी जो डेटा रे assault तक हुई.
So deceased हला पर बसी परिवनी. कि deceased हवा पूर्व बसी कौन मना है?
नहीं, जो रेट रे तक sir माने आक्रमण कराई जी. Can you see it? Can you imagine
Why-
that
why-
if
why can't
this
it sit?
can
Why?
sit, a person can sit scooty without
There is no,
putting that?
there is no
But-
medical impossibility. There is no medical impossibility.
ନାଇଁ sir, ଏଇ ଯୋଉ ଷ୍ଟେଜରେ ସାର୍ 3 ଜଣ ସାର୍ assault କରୁଛନ୍ତି ମୁଣ୍ଡକୁ ମାରୁଛନ୍ତି ସେ ଲୋକ ବସିକି ଯାଉଛି 5ଟା ଦିନ ପରେ ମରୁଛି। Sir,
So even if you say that PW5 is not a reliable witness because he has given something which is not acceptable, but PW1 is there, PW3 is there,
ହଁ, ସେ
and it's supported by the prosecutor.
ସେ କହିଛନ୍ତି ତାକୁ ମାରିଛି ବୋଲି, କିନ୍ତୁ our fault is that in correction question କରାଇନି, that is a great fault. That is a lack of experience, I think, the trial lawyer, that se question ପଚରାଇନି. Then what with the chemical court injury ଉପରେ କିଛି question କରାଇ? That was my fault, I'm admitting, but my client, so far as this incident is concerned, my client should not be an accused in this case. Sir, there's a question about family के नाम से।
Or 82 ଗୋଟେ file କର discharge ପାଇଁ ମାନେ passing ପାଇଁ ନା ଆପଣ କହିଲେ he should not be an
ସେଇ ଯୋଉ
accused.
କେସଟା କେତେ ରଖିଥିଲି କି ଆପଣଙ୍କ ମାଇଣ୍ଡ ଚେଞ୍ଜ ହବ ଟିକେ।
ମାଇଣ୍ଡ ମୋର ତ ଚେଞ୍ଜ ହୁଏନି ମୁଁ କଣ କରିବି?
21 ସାର୍ ସେ ଲଗାଣି 21 ସାର୍ ସାର୍ ଏଇଟା ଗୋଟେ ଇଣ୍ଟରଭ୍ୟୁ ଆସୁନହେଲେ ତ ଦେଖିବେ ତ
ନାଇଁ ଇଣ୍ଟରଭ୍ୟୁ କିଛି ହବନି ଡାଇରେକ୍ଟ ଏଭିଡେନ୍ସ ଅଛି କିଛି ହବନି
ସାର୍
କ୍ଲିୟର କେସ୍ ଅଫ ମର୍ଡର ମର୍ଡର ନୁହେଁ ଅତି ବେଶୀ 304 ପାର୍ଟ 2 ହେଇପାରେ ପାର୍ଟ 2 ହେଇପାରେ ଆଇ ଏମ୍ willing to accept that.
Another eyewitness is also there while Honorable Justice S.K. Sahu has been rejected.
Oh, yes, I have seen it.
Yes,
I have
that
seen it.
Pradeep Kumar Sethi, he has not been examined till date.
ପରିବାର କେହି ନାହାନ୍ତି, ସେ ମେଲ୍ ମେମ୍ବର କେହି ନାହାନ୍ତି, ଫାଦର ଇଜ ଇନ୍ କଷ୍ଟଡି ନାଉ, ଫାଦର ଇଜ ଇନ୍ କଷ୍ଟଡି, ଆସଲ୍ଟ ପୁଅକୁ ନେଇକି ତାକୁ ଜବରଦସ୍ତି ପୁରେଇ ଦିଆଯାଇଛି ଏଥିରେ। ସେ ଲକ୍ଷ୍ମୀ ତା ଇଣ୍ଟରଭ୍ୟୁ ବେଲ୍ ବି ସେ 2-3 ମାସ ଆସୁ, ସେ ତା ଘରେ ବି ଆଉ କିଛି ଚଳିବାକୁ ନାହିଁ। 2021 ଘଟଣା ଅଛି।
No.
ଆଉ ସେମାନେ ବି ସେମାନେ ଆଡମିଟ୍ କରି ଲ୍ୟାଣ୍ଡ ଡିସ୍ପ୍ୟୁଟ ରହିଛି, ପାର୍ଟ
ସେଟା ହେଇପାରେ ସେଟା ସେଥିପାଇଁ ଆପଣ କହିଲେ 304 ପାର୍ଟ 2 କୁ ଯାଇପାରେ
ଅଛି ସାର୍।
ପାର୍ଟ 2 କୁ
ତେଣୁ ଆଇପିଏଲ୍ ଲକ୍ଷ୍ମୀ 3 ମାସ ବାଟିଲେ ଆସୁ, ତାପରେ ଆସି
No.
ଆଉ 2021 ସେ ରହିଲାଣି ଆଉ
No. Another eyewitness is to be examined. ତାକୁ ଏখানে ଛାଡିବାର ଚାନ୍ସ ନାହିଁ ହବନି।
ଟେମ୍ପରିଂ ତ ହବନି।
ନା ସିଏ ଆପଣ ବୁଝିନାହାନ୍ତି।
ମୁଁ ତ ସେଇ
ଆପଣ you have tried, you have argued well, ଏଥିରେ କିଛି କହିବାର କଣ ଅଛି? I am not convinced ଆଉ କଣ କରିବି? My judicial conscience does not permit me to grant that.
ଖାଲି PW5 ଟାର
The petitioner
ସେଇଟା ମୁଁ ତାର ୱିଡ୍ର କରି ଆପଣ ଡିସମିସ୍ କଲୁ, ଏଇଟା
withdraw କରିଦେବେ
କରିଦେବି, ଫାଇନିଂ ଆସିଗଲେ ଅସୁବିଧା ହେଇଯିବ ତାପରେ।
କରୁନ
permitted to withdraw.
permitted to withdraw.
43
First time it has come. Second time 1 week time is allowed.
Item 44.
Wait, please, Your Lordship. My lord, the petitioner is in custody since 14/9/2021.
Sashikanta Kumar Behera. Earlier rejected.
Earlier rejected by this honorable court. I have annexed the orders. Annexure 2 series. On the last occasion, Your Lordship has called for the up-to-date CD.
You were granted interim bail.
Twice granted by this honorable court.
Yes.
And twice he surrendered in time. In the meantime, other accused persons have been released on bail. On 29/8/2023, as per page 25. DLAPL 1807/2023, Your Lordship granted 15 days bail.
You have obtained the case diary.
Case diary has not come, but in the meantime.
Oh, this is that Pakistan case.
Yes, my lord. Yes. That Chandipur.
I was very reluctant to grant bail. With a lot of difficulty, I have granted interim bail.
Yes, my lord.
Twice he has surrendered. My lord, my respectful submission. If they have not obtained, let them obtain, Your Lordship. But
and in the meantime, I think so more than 14 witnesses as on May 24.
Bring the copies of the depositions also. You have the copies.
I do not have the copies, my lord.
We can ask the court below to transmit them electronically. How does it work? London State Council requests for some time to produce the case diary.
Yes, ma'am.
He further submits. 14 witnesses have already been examined in the meantime. The trial court is directed to transmit the copies of the depositions of the witnesses examined so far electronically to this court. Does this matter? Out keep 24th September.
May I make a small prayer? Your
Yes.
Lordship? It again, this allegation is there. Thereafter, Your Lordship, I have tried to talk with them also. ତାଙ୍କ ସହିତ କଥା ହେଇପାରିଲିନି କିନ୍ତୁ କଥା ହେଲି. The photographs I'll produce, my lord. The photographs they show that the missile test range, everything I have shown, that is available in the Google map of the DRDO itself. That is what has been seized. The exhibits, whatever they have shown, whatever DRDO has shown on the net, only those photographs have been seen. It is not that I have shared any secret photograph. One mistake I have committed that I could not have done this chatting, Your Lordship. But he has been.
This is that honey trap case?
Yes,
honey trap.
I think
that is exactly.
has received some money also. Twice.
Because my marriage was
Twice.
fixed with her. Since my marriage was fixed with her, Your Lordship, for that reason, for house loan, I have obtained 27,000. It is not more amount.
Anyway, we'll see.
Yes.
Item 45.
Item 45. Piranti.
Acquitted, my lord.
Item 45.
My lord.
Yeah.
Depends upon the.
Tell infructuous
Yes,
you.
my lord, already acquitted.
All right.
बढ़िया.
Dismissed as infructuous.
Lordship dismiss को acquitted है गला bail पे दिले नहीं acquitted है गला नहीं dismiss को खाली dispose.
Dismissed with cost.
अब मोबाइल को ठेला आपको.
Lordship, it's a connected matter. The co-accused of the.
ये already चला देंगे ये जगह ने.
Which one is connected?
It has to be tagged along. That was the order 3860. It's not listed today.
Let it be listed. List कर दो.
Item number 46.
May I please? Well, this is an interim bail application.
Interim bail application no se no କହିଥିଲି sir copy ଗୋଟେ ଦବା ପାଇଁ.
Copy has already been served. Your Lordship may kindly see.
ଆରେ ମୁଁ କହିଥିଲି ମତେ ଗୋଟେ ଦବା ପାଇଁ ତାକୁ ସେଦିନ ସେ କହିଲା ମୁଁ ଦେଇ ଦେଇଥିଲି.
Office ରେ ମୁଁ serve
ସେଟା ତା ପୂର୍ବରୁ ଦେଇଥିଲେ.
ଖୋଜିଲେ ଆଜ୍ଞା ବାହାରେ 3-4
ମୋ ନମ୍ବରଟା ଅଛି
ମୁଁ ଅଫିସ ରେ serve କଲି ସେଟା ଆଜ୍ଞା କଣ
ମୁଁ instruction normally your lordship last your lordship has earlier rejected. Has earlier rejected. Man of Andhra Pradesh involved in another case in Andhra Pradesh. Therefore, your lordship was not. Your lordship was not inclined to grant bail. But at that time, my learned friend submitted that he has filed a interim application. On that day, he said that I have already submitted. Though he has served, I requested him to serve another copy that I can take instruction. That copy has not been served.
Copy of the IA is served on Sri Ganalok Mahanti. Leonard, you are CGC or what?
Senior Panel Counsel.
Leonard, Senior Panel Counsel for the Union of India in court. Let him obtain instructions with this matter next week.
Yes.
Next week, no,
again.
You obtain telephonic instructions.
Item 47.
Kichi document delan. Baba serious kichi document delan.
Local hero inquiry करो तो बुझो.
आके.
May I please your lordship?
Yes.
File the interim application 1120 by 2024.
1120.
1120 by 2024.
Have you served copy?
Yes.
Annexure 8 and 9.
Annexure?
The page number 8 and 9 of Annexure 1 series. The ECG report and the ECO report. In
Hey,
ECG,
what do you want? You want interim bail?
sir, left ventricular hypertrophy in ECG report and reduced diastolic compliance and systolic dysfunction in the ECO reports. And
What is-
doctor advised her.
You understand those things?
Sir,
Do you have understanding of those things? Because I don't understand. If you go on saying those technical things, what will I understand?
ECG and abnormal ECO and doctor advised her.
So she is suffering from the cardiac ailment.
Doctor advised her to admit in the hospital.
Please don't fold your arms. Please don't fold your hands. You are an officer of the court.
Okay.
You are of a very dignified profession. Please don't do that. You are doing your job. I am doing my job.
Sir.
I may agree with you. I may not agree with you. That's a different matter. I'm not doing, by allowing your application, I will not be doing a favor on you. Yes.
Earlier once rejected and once granted interim bail for 1 month.
Huh.
Now she has filed this IA.
Yes, sir. Indeed.
What do you say? You want to take instruction?
I will take instruction or that's it.
We'll take it up next week.
Mother is seriously ill. Sir.
Next week ja interim bail daba? Till you
I'll
obtain instructions?
Yes. And I will obtain.
No. Go to week mein ago interim bail daba till he obtains instructions. Thereafter I'll continue it if necessary. Next week, but you'll have to appear. You are from Rourkela. 1120/2024. This is an application for interim bail on the ground of serious illness of the petitioner's mother.
Yes.
Petitioner's mother. Several medical documents have been enclosed to the IA. Learned State Council requests for some time to obtain instructions as regards the documents so enclosed. So, Learned Counsel for the petitioner, however, submits that the condition of the petitioner's mother is very serious and that pending verification of the documents by the State Council, the petitioner may at least be released on interim bail for some time in order to arrange for immediate treatment of the petitioner, of his wife, sorry.
Mother.
Sorry, of the mother. I'm sorry. When can you obtain instructions? This is from Odisha.
Friday को भी नहीं आसी next Monday.
Next week, next Tuesday.
Yes, I will get.
Let's this matter on 10th September. In the meantime, let the petitioner be released on interim bail till 11th September 2024 on such terms and conditions. So that if depending on the instructions he has obtained,
Interim bail will be
this court will,
extended or
this court will consider whether to extend the interim bail or to close it at that point.
Item 48, my lords. Here, my lord, the commission offense, lords are contribute to see the increased act, my lord. Petitions is custody 6722, my lord.
Yes, what is this, Mr. Bhamta?
Statement, my lord.
20B2C.
My lord. As per the
Kete kg?
Here, my lord.
640
my
kg.
lord, but petition not in spot, my lord. Kindly class case 12, my lord. Only
This is a remand case, my lord.
FR, my lord.
Earlier, he was arrested in same 20B2C case. Thereafter,
that is only acquitted, my lord. Kindly class page 12, my lord. Only khali place 12 khali as per the investigation option. Page 12, para 9, my lord. While approaching the
Page 12
spot, we found two persons.
Page 12 kahin kood porchunde apno? Page 12 is plain paper FIR.
No, my lord.
yes.
Page 12 ହେଇଛି?
My lord, page 12. 3, 6, paragraph line 10 रहे. While approaching the
bro, ମୁଁ ଟିକେ 10 ଯାଏ ଯାଏ 3 4 5 6 7 8 9
ହେଇଥିଲେ ବୋଲି କି
କଣ ଲେଖିଲେ? On the way I arrest two independent witnesses, namely so and so present. While approaching the spot at distance of 250 PM, we found
two persons which is from Jaribat, my lord.
Middle paragraph, your lordship. I'm being asked.
Near the resolution, all of sudden we all hero them, finding presence of the police. They tried to escape from there.
What is your name?
My name
Runa Lima.
Runa,
So co-accused statement.
Co-statement.
Who escaped from the spot is Runa Lima.
Runa Lima. See, no total spot, my lord. See, the coach and Dion Chidai, the
Oh, but in the earlier order, I have written that he was arrested at the spot.
Sorry, my lord, that time we have with the knowledge,
He was arrested at the spot. Why? Where was he arrested? Let us see. Or he was taken on remand.
Taken on remand, my lord.
Okay.
Lordship, see that
another case, my lord.
rejection order.
Another case, my lord. Yes, you need 6. FR is 11, 21.
Lordship, see the rejection order, page 18.
That case already acquitted, my lord.
Third last 10 lines. The present petitioner was in custody in connection with Padampur PS case number
85.
Search.
Was remanded. Okay.
He is remanded in this case and by that.
Arrested, my lord.
All.
Remanded, my lord. Remanded, my 22/8/22, my lord.
So in this case, he was taken to custody on 22/8.
No, my lord.
Akintu.
जो केस रे सेटा धरले ताकू जोटा एक्विटल हेले सेटारे ताकू धरले एटा होची 11/11/21 इज एफआईआर, my lord.
Seita apun bujuna. So he was arrested. He was in custody in connection with some other case.
My lord.
All right.
My lord.
So when this case was registered in the month of April, subsequently during investigation,
yes,
his complicity having been found, he was taken on remand.
एटा आगे हिच आगे एटा 21 ले आगे.
I mean, 21 ହେଇଥାଇପାରେ, but he was taken on remand in connection with this case. This is
arrest हेई गले तापर
Padmapur case PS case number kete?
85 में.
85
he was played away. He was absconded.
सेटा acquitted हेई गले.
ठीक गोटे मिनिट.
It already acquitted, my lord.
No, PS case number 85 ta relates to this case.
My lord.
Here you were remanded on 22/8/2022.
No, 85 is another case. Now what case re se dhara ite setare on the spot, my lord.
So ei case re kebe arrest hela?
Eta arrest hei na jetlo seta se arrest hei gele eta se remand kor dela 20.
So that is what I'm saying. That is what I'm saying.
My lord. Eta ke dekne ke repose re tara.
No, ei FIR number ta kete dekhi. FIR number টা কেতে?
এইটা হচ্ছে FIR my lord,
And 96.
এইটা হচ্ছে 96 my lord,
So when was he arrested?
11L21 my lord, ই arrest ହେଇନଥିଲା ଆଜ୍ଞା
Arrest ନ ହେଲେ remand ତ ହେଇଥିବେ.
my lord.
When is where is that date? What is that date?
Kindly glance the rejection order my lord,
କୁହନ୍ତୁ.
page 18 my lord.
ସେଇ
Remand-
22
remanded in
ଆଠ
22
22
ମତେ ଆର ଗୋଟେ କେସରେ ମତେ 7 ରେ ଧରଲେ 6-7 ରେ ଧରଲେ, ଏଇ କେସରେ ରିମାଣ୍ଡ ପକେଇଲେ ମତେ 22/80/22
ଏଇ
my lord.
କଥା ତ କହୁଛନ୍ତି ସାର୍।
ଯୋଉଟାରେ ମତେ ଧରଲେ, ଯୋଉଟା ମୁଁ ସ୍ପଟରେ ଧରା ହେଲି ସେଟାରେ ଅଲଗା କୋଟେଡ ହେଇଗଲିଣି।
This is what I have been saying repeatedly. So this is co-accused statement. isn't
Co-accused
it?
statement.
The petitioner is in custody on since 22/8/2022, being remanded in connection to such and such case.
Hello.
It is submitted that his earlier application for bail was rejected by this court as per order passed in BLAPL number 11813 of 2023. ଆପଣ କଣ ଏସବୁ ସକାଳେ ଆସିଥିଲେ ଉପରୁ ଆସିଥିଲେ? ସକାଳେ ବି ଆପଣ ଆସିଥିଲେ? 11813 of 2023 on the ground that he was arrested at the spot. Stop. It is submitted that the facts of the case could not be properly explained, could not be properly presented before this court, as the petitioner was not arrested at the spot, but being in custody in connection with another case, that is Padmapur PS case number 85 of 2022, he was remanded in this case. Stop. It is further submitted that from the FIR itself, it would be apparent that the petitioner was not present at the spot and was implicated solely basing on the statement of the co-accused persons, who were detained at the spot. Stop. Learned State Counsel, while opposing the prayer for bail, fairly submits that the petitioner was not arrested at the spot. He further submits that the petitioner is a habitual offender being involved in similar case. Stop. In response, Sri Mahunta learned counsel for the petitioner submits that his client has already been acquitted in the connected case, in the other case. Stop.
ଗୋଟାକରେ acquitted, ଆଉ ଗୋଟାକରେ bail already ହେଇଛି।
In another case, as also on bail in another case. Stop. Be that as it may, this court finds that from the FIR, in the FIR itself, it is clearly mentioned that the petitioner's complicity came to light on the basis of the statement of the co-accused persons. There is no other evidence to show his involvement in the alleged occurrence. Stop. As such, the ratio laid down in Tofan Singh versus so-and-so squarely applies to the facts of the case. Stop. In the above circumstances, the bail application is allowed. Let the petitioner be released on such and such. Condition Korantu 1. He shall appear before the IAC of Kothana
Padmapur.
on Padmapur police station on every Sunday at 10 a.m. till conclusion of trial. External, he shall appear before the trial court on each date of posting of the case without seeking representation through lawyer. That's all.
Okay.
Item 49.
ଆଇଟା not pressman.
Okay.
You lordship director. Last of the lordship director file आइए।
आइए तो नहीं
Last what's file was.
आइए नोट पेस्ट आगे लिख दो।
Item 49, my appeal project. The present petitioner is in custody since 9/11/2021. In the meantime, all other co-accused persons granted bail. This is the second journey of the present petitioner. On last order, lordship directed the learning court below to conclude the trial within a period of 6 months, but not concluded yet. Only 2 witnesses have been examined, and they turned into hostile. The by the order dated 25/8/2023.
Where is the?
Then
Where is the, you have the copies of the depositions of the witnesses?
in another case I have filed.
Your Lordship kindly have a glance, page 23.
No, no.
Everything mentioned in that order. Recently, Your Lordship granted bail another co-accused in Lords.
Niranjan Naik and Arjun
Yes.
Nahaka.
So I will imagine what they have said in those two cases. I will pass that order. No,
No, sorry.
no, in that connection, যেহেতু এই order আমি লিখে দিয়েছি ভুলরে to renew her prayer after examination of two witnesses, Niranjan Naik and
No,
Arjun Naik.
that is different. That bail is another co-accused, not the present
There is
petition.
a mother in.
Sir, you asked me to see page 23 though.
No, Your Lordship granted bail. That's why I annexed that order.
All right, all right. So how do I know what the witnesses have said?
I have the reportion copy, but not annexed.
ଦିଅନ୍ତୁ ନହେଲେ ଗୁନ୍ଥିବି ମୁଁ ଦିଅନ୍ତୁ ଯୋଉ ଫୋଡନ୍ ଆଣିଲ ଟ୍ୟାଗ ଫ୍ୟାଗ ଆଣିଲ ଗୁନ୍ଥିବି ଆଜ୍ଞା ମୂଳରୁ ଯାହା ପଚାରୁଛି ଆପଣ ଶୁଣୁନାହାନ୍ତି କାହିଁକି କଥାଟା give copies to the state council also. How will he then conduct the case? You have copies? Mr.
No,
Mishra?
my lord, no, my lord. Yes, no.
Give him copies. We'll take it up maybe day after tomorrow or Friday.
Yes.
Copy करूं?
Copy दे दो.
Day after tomorrow. All right. Learned counsel with the petitioner files copies of the depositions of some witnesses examined so far in the court. Let copies thereof be also served up of the state council. Let this matter day after tomorrow.
Okay.
Item 15, Lordship. Extension of time in respect of petitioner number 2, Lordship. This is the
First time it has come. All right. Petition number 2, 2 weeks time.
Item 15.
Lordship. Document section 28 of ND and 29 of NDP. Lordship, the confessional statement of the accused person before police have been implicated in this case. The accused person already entered bail by this honorable court, Lordship. And so far I have not named the FIR.
So, why are you apprehending arrest then?
Lordship, during confessional statement of the accused person, I have
Your name has come to light.
implicated, Lordship.
But FIR doesn't say so, man.
Lordship, so far the case is concerned, the accused named in the FIR, they have already been acquitted in this case.
No, no. That your name has been spoken by that co-accused. Where is that statement?
Lordship, in page 14, the FIR portion, the second paragraph. When they ask about the identity of the other accused persons who fled away from the spot, Karuna Hilal disclosed that Govinda Kushila is the present petitioner. And his associates Sunil of Tikar, few other Bethal Nagar, one Vikas Kusilia of Hattamunigoda and few Malaypuda were also present at the spot and members of the crime syndicate.
Yes, Mr. Mishra.
Clear भी नहीं.
Clear बिल्कुल नहीं.
Page 14. এটা তো page 14 अलग আছে क्या? Page 14 is total different matter.
There was a defect of legible copy. After corrections of the legible copy, I have not filed for the state, so unable to read the.
All right. Give a legible copy. We'll take it up day after tomorrow. Let a legible copy of the statement 161 statement of.
Let's say 161, the FIR portion.
Let a legible copy of the FIR be served up on the state council. By tomorrow, let's this matter day after tomorrow.
Item 52.
May I
The lordship suggested to file IA on that previous case.
Yes, I have
Which has
already
been
filed.
disposed of.
Already filed and given memo that I yet not yet even.
সেটা আসবো এই মেমোটা আলো হইতে আসবো নম্বরটা give the number list that matter ହେଲା list that matter this will just remain সেটা যৌদিন লিস্ট করিব এটাକୁ সেদিন নিয়ে আসবো list this matter on such and such যেটা ডেটটা তুমি কই দিও সরিগলা পাসওয়ার্ড নেই
Sorry.
ভেরি গুড नहीं प्रथम पूरा पासवर्ड ওটা সারিবে না না সরি পাঠাড় ওটা পাসওয়ার্ড নেই পাঠাড়টা ঠিক ওটাকে নেই যে এই সিনিয়র কাউন্সিল বসে ওটা
Item number 3. Quickly list item number 3.
Yes, in that case, which has been the second appeal which has been preferred by the state, After a long delay.
Three is not yours.
Oh, sorry.
Three is not yours.
Carried Kali. I'm sorry, I beg apology.
ମୁଁ ବିଚରା କାଲି ରାତିରୁ ପଢାପଢି କରି ଖୋଜାଖୋଜି କରି ଆସିଲା ବେଳକୁ ସେ ତାଙ୍କର କଲେଣି। I have made little further study in the matter. I have found two MP High Court judgments which are against me, supporting your lordship's view, the judgment which passed by my lords. I have found one Supreme Court judgment which is in favor of my view.
This is that Supreme Court judgment again? Yes.
99 MP ta 78 2 SCC 542 is in
directly देखिए वो MP क्या देखिए?
Sir, Supreme Court देखिए। हाँ, ठीक है। इतने again just to remind my lords, just to refresh the memory. से जो Sumitra, wife of Prahlad died. Sumitra became widow, inherited property from Prahlad. That property, after she became widow, inherited the property on section 14, becomes her absolute property. Now she married to some other person. After marriage, children were born out of the second marriage. Now question is, after death of Sumitra, whether children through second marriage will inherit or heirs of husband will inherit. This is the short point. Now what I am trying to tell, if your lordship sees sections 15, 2B is the law governing the field. But while I am trying, this is an issue which your lordship will probably decide will have a larger public impact. Issue of succession, right to succession. Sir, why did you laugh? Why did you laugh? I am speaking of my submission. Why are you laughing, sir? It's not good gesture. Why are you laughing? I am saying, as per me, it is of public importance. Subject to my lords will accept, not accept. But I say, I repeat it again, it's huge public importance because that will govern the field of succession and inheritance.
Hindu Succession Act.
But why I am saying, if your lordship sees section 15(2)(b), section 15(2)(b), what all your lordship judgment, the country Hindu Succession Act.
Yes.
Sir, all your lordship judgment, Justice A.K. Rath's judgment, Justice Raghuveer Das judgment, including this 2 MP High Court judgment, Bombay High Court judgment, all the judgments have only considered section 15(2)(b). But if your lordship sees section 78 Supreme Court, section 15(2)(b) cannot be interpreted in isolation. 15(2)(b) is to be read with section 16 rule 3 of Hindu Succession Act. If your lordship sees section 15(2)(b) read with section 16 rule 3 of Hindu Succession Act, your lordship will find that there is a legal fiction. What is that legal fiction? Legal fiction is, in case of death of Sumitra, your lordship has to interpret the legal fiction is, as if the husband is dying after Sumitra, and in that case, section 8 will come into play. That is what is said by Supreme Court. Am I clear, my lord? Am I clear how I am saying this? If your lordship sees section 15(2)(b) read with section 16 rule 3, there a legal fiction is drawn in case of succession governing under 15(2)(b). What is that legal fiction? Your lordship has to interpret and see that husband, even if died prior to Sumitra, will die after Sumitra. That is the fiction. And succession will be governed under section 8. Meaning thereby, class 1, then class 2 heirs of husband. This will be one part of my argument. Second part of my argument is that 78 Supreme Court decides, in absence of any son and daughter of the deceased, means son and daughter of the deceased means deceased widow. Son and daughter is interpreted the son and daughter of the first husband, not the second husband. This is what Guwahati High Court says. So therefore I say it's an issue of larger impact. If your lordship considers my point as an arguable point, may refer the matter to a larger bench for a decision. Subject to my lords consider it. If your lordship finds that I have a point on this,
no, I will pass the judgment. You may challenge it.
No, that definitely not. That's a different matter whether client can carry or not carry. But in my humble opinion, if I am able to satisfy,
that is if you are aggrieved. My judgment will be in your favor. Who knows? It may be in your favor.
Once your lordship has said without considering section 16 rule 3, that will be a per incurium. Because section 16 rule 3, that legal fiction has not been considered in none of the judgments of our High Court.
No, but I'll tell you one thing.
Right, man.
You must also consider this.
Right, man.
All these provisions,
yes,
they do not contemplate a situation of a widow remarrying.
Yes, widow. Yes, contemplate a situation.
Where is it?
That's what I'm showing.
Please.
Kindly see, my lord. Kindly see first section 15(1) to 2b. Kindly see.
Yes.
See, my lord, any property, if your lordship says, your lordship will straightway draw from this.
Yes, place it.
Any property inherited by a female Hindu from her husband or from her father-in-law shall devolve in absence of any son or daughter of the deceased. Kindly mark the language. Of the deceased, including the children of any predeceased son or daughter, not upon the other heirs referred to in subsection 1, in the order specified therein, but upon the heirs of the husband. Right, madam?
Still, it does not contemplate that situation.
But if
it only says
it on a
let me, whatever I have understood, let me tell you. Again, this may not be my final opinion. And
right.
Always we are subject to change.
Correct, my lord. Correct.
Law is a dynamic concept.
Absolutely correct.
There cannot be a straight jacket.
Why we are studying, my lord?
We are all times we will close ourselves.
That is why we are studying every day.
You see, any property inherited by a female Hindu from her husband or from a father-in-law shall devolve.
Yes.
In the absence of any son or daughter of the deceased, Setigre
Rohigala, sir.
Remarriage kotha kohuna.
Sir, kohunanti.
But what situation? It does not envisage situation where the widow goes on to marry.
Sir, upon a Setigre Rohijantu. Say it, let us take a pause here. In absence of a son or daughter of the deceased. It Rohijiba. Let us pause it here.
Yes.
Then, what is the meaning of son and daughter of the deceased? Ita katha ho Etita katha? Kindly see that 78 Supreme Court. Sir, dekhan. This is the view of other high courts upheld in this judgment. Kindly see para 9.
Para 9.
Sir.
Yes.
In second appeal filed by the plaintiff, High Court following the earlier decision in so-and-so case held that Bhumi Swami and Bhumidhari rights are not tenancy rights, and section 151 of Madhya Pradesh Land Revenue Code 1954, which deals with the devolution of interest of a Bhumi Swami or Bhumidhari tenure holder, cannot be regarded as a provision dealing with the devolution of tenancy rights. Section 4(2) of Hindu Succession Act is no way safe section 151 of so-and-so, but it's not very relevant. Then kindly see Revenue Code, and it cannot be held that section 14 of the Hindu Succession Act doesn't affect the personal law according to which devolution of interest of a tenure holder passes on section 151. Means 151 is taken away. That Hindu Succession Act will prevail upon. Next, kindly see. High Court further held that expression heirs of the husband in section 15, 1b, as also 15(2)b, refers to the heirs of the deceased husband. We would have succeeded under the provision. Sir, who would have succeeded under the provision of the Hindu Succession Act if the husband had died on the day on which female intestate actually died. On these premises, High Court held that the plaintiff Srimati Gopika Bai falls under clause B of section 8 and as such is entitled to succeed in the preference of the agnates coming under clause C of that section. In the result, plaintiff's appeal was allowed and the decree of the trial court was restored. This is the view upheld in this judgment. Now your lordship may see section 16C, rule C. Kindly see. What is that section 6? Therefore, I say 15(2)b cannot be read in isolation.
Yes.
Kindly see, my lord. That the very pertinent question your lordship asked is, where does it say question of remarriage? Kindly see here. Here is a succession governed under 15(2)b. That is admitted position. Kindly straightway see rule 3. Devolution of the property of the intestate on the heirs referred to in clause B, D, E of subsection 1. We are not concerned about. And in subsection 2 of section 15, which is the provision we are governed. 15 shall be in the same order and according to the same rule as would have applied if the property had been father's or mother's or the husband's, as the case may be, and in such person had died intestate in respect thereof immediately after intestate death. This is the fiction. This is the fiction. And subsection 2 of section 15 is the only provision general rules of succession of a woman. Then 16 also succession of a woman. So 15(2)b cannot be read in isolation. It has to be read under section 16(1), rule 3. Rule 3 covers 15(2)(b). Means, Lordship will kindly interpret here. The legal fiction is husband will die after death of the widow, and after his death, section 8 comes into play as is held in the 78 Supreme Court. Once section 8 comes into play, in absence of class 1 heir, it will go to class 2 heirs. Am I clear, my lord?
Yes.
That is what Gujarat High Court said. That is why I say it's an issue of highly important issue.
All right.
I have read it. I have done research on
So
this.
I'm closing it then. Anything further?
I'll place some more paragraphs from 78 Supreme Court.
Yes. I thought you were done.
I
thought you had completed.
I take care, sir.
Yes.
I'll take care, sir.
No, please go on.
Sir, para 30 देखो page 12. Sir, ta purburu
29.
Let us read it from 29, para
Yes,
29.
yes.
That is the governing provision. The general rule of succession in the case of a female Hindu dying intestate are given under section 15 of the Act, which so far as is material for the purpose read as follows. Property of a female Hindu dying intestate shall devolve upon Sir, 8 sir, according sir 8 section 16 ta आपण जो पचारले section 16 comes with 15(2)(b). 8 लिखा है सेई पे मु पढुचे एटा.
Yes.
The property of a female Hindu dying intestates are devolved upon according to rules set out in section 16 upon the sons, daughters, so and so upon
Excuse me. Yes.
Upon sons and daughters, upon the heirs of the husband B, C to E, notwithstanding anything in subsection 1, any property inherited by a female Hindu husband from her, which I have just now read 15(2)(b). Am I clear, my lord?
Yes.
Kindly see section para 30. This section should be read along with the rule set out in section 16, which I said, my lord. The material part of which runs as under the order of succession among the heirs referred in section 15 shall be, and the distribution of the intestate's property among those heirs shall take place according to the following rules, namely rule 3, which I just now placed, my lord. Section 16, rule 3. The instant case will fall under clause B of subsection 2 of section 15 because Srimati Sarji died issueless and intestate. Interest in the suit property was inherited by her from her husband. The suit land will therefore, under clause B, go to the heirs of the husband Punja. But you got it, direct answer from this provision, this judgment, my lord.
Yes.
So this is what I say, kindly see thereafter also. The next question is whether heirs of the husband in section 15 are to be read ascertained with reference to the date of Punja's demise 1936 or with reference to the date of Srimati Sarji's death 1956 when succession opened out. There appears to be some divergence of opinion among the high courts on this point. We are, however, of opinion that once it is found that case falls under section 15(2)(b), the fiction envisaged in rule 3 of section 16 is attracted, according to which, for the purpose of ascertaining the order of revolution, it is to be deemed as if the husband had died intestate immediately after female intestate's death. Bearing this fiction in mind, we have then to go to the schedule of section 8 of the Act to find out as to who would be the heirs of Sarji's husband on the date of her death. Kindly see, my lord. Section 8 of the Act provides this. So straight away, direct line, 15(2)(b), 16 sub rule 3, then 8.
Yes.
So that is why I say, my lord, since your lordship has already delivered a judgment without taking note of section 16 rule 3, none of the judgments, your lordship will find the judgments I have filed. And I have also filed the judgments which are apparently against me. All the judgments do not refer to 16C, rule 3.
All right.
So I'll humbly request before my lords, if my lords find that there is a point of law involved here, and that is in deference to my lord's view in the judgment, either your lordship can refer the matter to the larger bench or deliver a judgment, whatever your lordship feels proper. So grateful.
Sir, how come?
Milord, my learned friend, Milord, on the facts of the case, I have challenged that Milord lower appellate court judgment on the basis that though the trial court declared that I am the legal heir, successor, and the defendant for whom my friend is appearing is not the adopted son. That finding, Milord, confirmed in the appellate court almost, except the point that the lower appellate court also Miller declared, I am the legal head of the Sumitra. But he said that the property, the suit property, she is not entitled. That means both the courts confirmed that I am the legal head. That judgment is challenged before your lordship. Miller, first of all, your lordship kindly see. I am the branch of Lakman. He is nothing to do with my branch. Prahalad, this is the property of the Prahalad. Prahalad married Sumitra, who Prahalad died issueless. By that time, the property I have inherited from my husband, I continued. Thereafter, there is a settlement. In the settlement, the land was recorded in our name, in my name. As a full owner, I enjoyed the property till 84. 84 Millard, I remarried, Sumitra remarried Rameswar. Through her, he got the child, the present plaintiff. Now, when the defendant number one, he filed a mutation claiming he is the adopted son of Sumitra. And Sumitra being married, she has forfeited every right in the property of Prahalad. That was his case. And he got mutated the land in the name of, which was stood in the name of Sumitra as a adopted son. He came to the field. That I have objected. He said in the mutation Millard that Sumitra is issueless. That I will show. That is also exhibited in the court, and that reflects Millard. There are exhibits. Now, your lordship kindly see the appellate court judgment.
I've seen all that, sir. You have already argued.
No, I am the question which my land friend is raising is nothing to do with the present case. It is a separate case. You can argue in appropriate cases, not in this case. In this case, only issue was that though both the courts held that I am the legal head and I am the successor of Sumitra, but not in respect of the property of the husband, that the property will not in respect of the property, it will go to the heirs of the Prahalad, if any. Admittedly, Prahalad, Millard, Sumitra, there is no issue. They have no child. And this is the only child. And your lordship interpreted, and Justice Raghvir Das Millard, your lordship, that is all the questions he has Millard discussed. So my case, Millard, your lordship kindly see, relying on the 2003 Guwahati, the lower appellate court has come to the finding that Millard, your lordship, that that L is that lower appellate court judgment.
Lower appellate court judgment, yes.
So my respectful submission, my friend, whatever submission has made, legal points has raised, that is not relevant in this case. In the appropriate case, the point raised may be correct, but not applicable to this case. And that is not involved here. Your lordship kindly see page 5 of the Millard, page 40, running page 40 and internal page 6. Your lordship got it.
Yes.
In the case of Srimati Darshinta Kalia versus Ramakrishna Kalia and others, reported in year 2003, Guwahati 92, it has been held at para 20 as under. Since the object of section 52 to ensure the property left by a Hindu female does not lose the real source from where the deceased female had inherited the property. one has to option but to hold that son of daughter, including children of by predeceased son and daughter of such Hindu female, will mean the son and daughter begotten by Hindu female from the husband whose property she had inherited. That is wrong, Miller. And not the son and daughter whom she had begotten from the husband of other than the one. This was the issue. On the basis of this Miller Guwahati High Court judgment, he has declared that the property will go to Prahalad because there is no issue. The daughter born by second husband, that is present plaintiff, has nothing to do, it will go to the, that is the decision was made here. Now the question, Miller, under section 14 of Hindu Succession Act. Property of a female Hindu to be her absolute property. Here there is no dispute that she has inherited property from Prahalad. There is no dispute. Even after Succession Act came to force, she continued. And as a owner of the property, she enjoyed. And the settlement also thereafter, when in the 77, there was a settlement. In the settlement, the lands were in all recorded in the Khata, all the lands in my name. That is not also before 80 marriage. So I, as a full owner, I enjoyed the property. If that is so, Miller, if a full owner as I enjoy the property, my respectful subject to Miller conditions, this 15.15.2 is not relevant because I am the full owner of the property. I got the property. It is, I can do anything as required if my property. Your Lordship, kindly see that I have got two decisions in the point. One, the trial court relied upon the 83 Patna, wherein the trial court has taken that Hindu Widows Remarriage Act and Succession Act, the section 4, and thereafter, even there is not deleted. That is small decision of 3 pages that is relied by the trial court and came to the filing. Another thing, my land friend argued last time. He has submitted the note and he has not given the note. I also asked the note to give. And on that date, I asked to supply the note and distance what he has relying. That is not given till today. And now he has given some one pair, some citation. It's not the proper procedure we follow in the High Court. I'm sorry.
No, but I will close it today.
Not given.
No, I will close it today.
I am saying, in spite of that argument, that is not relevant in view of that Hindu women's. Here, this is the copy. Here, as a full owner, inherited with property on my own, that after remarriage, your Lordship, kindly see the plastic death copy.
This is almost the same view that I have taken.
Millard?
This is the same view I have taken in my judgment. Without referring to this, almost the same view. The remarriage will not divest widow of the inherited share. Rightly, wrongly, I have taken that view. I'll now examine what Mr. Athwa has said.
Supported. This view was taken in 1900 to 2008. Supreme Court approved the decision. As said, the point is no more reciprocal. It is clear. That will at 2008 Supreme Court.
Well, that's true, but I'll have to now consider my judgments in contrast to what Mr. Athwa has argued.
That is what he has argued, not relevant.
No, that's true. That's true.
Even
Whatever you have said. Sir,
This is my case here.
sir, I cannot, you may argue that, but I cannot straight away say that it is not relevant. I will have to consider.
That you have your lord, this is where our submission. He has submitted something where the point is not involved here.
Okay,
That's why I said the decisions may be correct in the facts and circumstances of that case, but not the facts and circumstances of this case, where I have pointed out your lordship.
Yes.
This also approved by the Honorable Supreme Court at paragraph. Your lordship kindly that 283 partner I will first, two
Yes,
paragraphs I will.
you have
take.
given.
Your lordship kindly see paragraph 6.
When it is said, yes, I think
From the
previously
bottom,
also.
from the bottom, 9th line.
Yes.
Now, under Succession Act, a widow inherits simultaneously with the son, daughter, and the others heirs specified in class 1 of the schedule, and the exclusion of all other heirs. Section 14 provides that any property possessed by the female Hindu, whether acquired before or after the commencement of the act, shall be held by her as a full owner thereof, and not as a limited owner. Therefore, the widow takes her share absolutely and not as a widow's estate. Remarriage by a widow cannot therefore become a ground for divesting the estate in the inherited property. This is the clear answer given in the facts of my case, Miller. This decision was approved in 2008 Supreme Court. That paragraph, Miller, your lordship kindly comes. Relevant paragraph is paragraph 11 and 14. The question posed, the act, para 11, Miller.
Yes.
The act brought about a sea change in Shastric Hindu law. Hindu widows were brought on equal footing in matter of inheritance and succession along with the male heirs. Section 14(1) stipulates that any property possessed by a female Hindu, whether acquired before or after the commencement of the act, will be held by her as a full owner thereof. Para 14. Referring this 1983 partner, the question posed before us is no more res integra. In Chentu Mehta versus so 83 partner 33, the Patna High Court opined the Hindu Widows Remarriage Act 1856 has not been repealed by Hindu Succession Act 56, but Section 4 of the latter act has been overriding effect and in effect abrogates the operation of the Hindu Widows Remarriage Act 1856. According to Section 4 of Hindu Succession Act, all existing laws, whether in the shape of enactments or otherwise, shall cease to apply to Hindus in so far as they inconsistent with any other provision contained in the Act. Thereafter, Millard, 2 decisions, 76 Supreme Court, Kerala High Court, they say the remarriage of the wife cannot be ground for her losing right succeeded to her deceased husband's property. So, Millard, my respectful submission is, being a full owner, inherited the property from the husband, and in view of the after remarriage, that will not go back to the husband. And your lordship also, paragraph 8 and 9, dealt with, posed a question and also answered in paragraph 17. Paragraph 8, your lordship kindly see.
Judgment number 2 about the decision note tadelo.
I'm giving the copy.
Notice of judgment.
No, you don't have to. I think it is there. I will. Ashadhi.
para 8 Miller, that after 8th line, the first appellate court
Yes.
therefore referred to the provision under section 15 of the Hindu Succession Act and the Mullah's principal Hindu law and judgment of Bombay High Court in the case of Ram Anand Patel and so and so to hold that the children of Golab fathered by defendant number 2 have undoubtedly an interest in the property of Golab and their all legal heirs as specifically entered in section 15A of 15(1) of the Hindu Succession Act. Further, Golab being the widow of Natwar and a member of the undivided Hindu joint family, interest of property of her dead children so and so. Thereafter, para 9, your lordship formulated the question whether the children begotten through remarriage of widow are entitled to succeed the property of the estate. This is the direct point, Miller. This is necessary to be decided in my case, in facts and circumstances of my case. Miller, para 17, your lordship kindly come. That is
Para 17.
Page 17, Miller. Para 17, page 14.
Yes, I refer to the Bombay High Court decision.
Bombay High Court decision. Thereafter, Miller, in case of female initiator had remarried after the death of her husband or after divorce or sons by different husband. And
No, that was my view. It's all right. That was my view. Now,
this Miller, now the next question, similar point, same thing was in the judgment of Honorable Justice Raghuveer Das Miller. Miller, para 12 to 15 Miller. Para 12, in Kesarilal, repairing a decision of the MP High Court Miller, next page, they are born to the husband whose property is in dispute. I am placing that. The question to be answered as to whether what son should be restricted to son and husband from whose Hindu female inherited the property, or it should include sons and Hindu female irrespective of whether they are born to the husband whose property is in dispute. While answering the question, his lordship observed that from the language used in subsection 1 and 2 of section 15 of the Act, it is clear that the intention of the legislature is to allow succession of the property to the sons and daughters of the Hindu female, and only in the absence of any such heirs, the property will go to the husband's heirs. As was in the textbooks of Principle of Hindu Law, Dr. Mullah, it is commented on section 15(1)A of the Act that in case of female intestate who had remarried after death of her husband or after divorce, her sons by different husbands would all be her natural sons and entitled to inherit the property left by the female Hindu, regardless of the source of the property. The Guwahati High Court, in my case, Miller, basing on which he has said, she is the successor, but she is not entitled to succeed the property of the first husband. That was dealt with in this case, Miller. In the Guwahati High Court, conclusion that son or daughter of a female will mean the son and daughter begotten by her from the husband whose property she has inherited, is based on the observation made by the Honorable Apex Court in Bhagatram case of Supra. This Supreme Court judgment has been cited by both the parties. Then counsel for the appellants put much stress on the Honorable Apex Court's observation that the source from which the Hindu female inherits the property is always important. Otherwise, persons who are not even remotely related to the person who originally held the property would acquire right inherit property and would defeat the intentional purpose of section 15(2). In my considered view, The said observation of the Honorable Apex Court applies to a situation where the female Hindu has dead intestate, leaving behind no issue born from to her. This is the Millard. Clearly it is made. Thereafter, Millard, he has taken 87 Supreme Court and interpreted that children born son and daughter, that includes natural son and daughter and also second husbands. In this case, Millard, the property inherited by the widow from the second husband, they have no issue. So the court has gone to the extent. Daughter means he included natural daughter and also accepted that property will go to that. So, here another my submission is whether my learned friend has any locus standi to argue the matter after the appellate court judgment. Here is a case. He entered into the picture saying after the death of Prahalad, she is security, no security is there, helpless. In that situation, she wanted to adopt. He said, according to him, she Sumitra adopted the dependent one, the Trinath Barik. Trinath Barik Millard, immediately thereafter, he said, after remarriage, she forfeited everything. So naturally, as an adopted son, I am entitled to that property. That is his story, and filed a mutation. To change the name in the ROR, in the place of my name, Sumitra name, he wanted to come in and Miller record his name. So that was disbelieved by both the courts. He has not challenged it. Second, Miller, the second prayer of the plaintiff, the present appellant.
And I'll reply. Definitely, I'll have a right to reply, madam.
Yes,
Because
yes,
the facts are again repeatedly argued. I'll reply, madam. I'll reserve my right to reply.
You have a right.
Yes, yes.
I am not saying no. I am placing my case. These are the circumstances where the arguments is not applicable. That is your lordship to consider. That's why I am placing the second, Miller, the second prayer of mine. The appellant is, she is the only legal heir of Annapurna, the Sumitra. That was declared by the trial court, relying upon that 83 partner. And Miller, thereafter, the appeal filed by them, that was also confirmed, only varied to the extent the appellate, both the courts accepted that I am the legal heir, and only varied to the extent not to the property of Prahalad, because there is no issue, it will go to the Prahalad's branch. So in view of this, he came to the field and entered to this thing, stating the adopted son. Both the courts disbelieved Miller, and even the second aspect, he has nothing to do with the branch of Lakshman. The property belongs to Prahalad. So even Miller, the appellate court has said it will go to the legal heirs of Prahalad, if any. In this case, Miller, admittedly, Prahalad has no legal heirs. So it was excluded him also. In view of that, my respectful submission, he has no locus standi to make any submission in this case.
All right. Well, I'll reply. Because the facts are submitted. If the law would have been addressed only, then I would have no problem. He repeatedly argued the facts. Lord, first of all, Lord, the very facts
have already been argued. You have also given a reply. Because I intend to close it today. No, just.
Sir, I have heard everything. I have taken note of. My junior has taken note of. That's not an issue.
Yes. I'll complete it today. I'll complete it. I'm closing it today.
The first submission was made with regard to applicability of 15(2)(b).
That I will examine. Set a point of law. I will examine.
15(2)(b) and 16 are only provisions applicable. The reason being, here is a case. Vesting and divesting of the property is not the issue. widow inherits the property, section 14 becomes her absolute property. But what will happen on her death? It is only section 15, 15(2)(b) and section 16 rule 3. No other provision are in the Hindu Succession Act. So it is absolutely misconceived, fallacious to say that 15(2)(b) is not applicable.
Yes.
My first reply is this. Second is, Asperson was cast saying that we are High Court practitioners, judgments are not served on them. My lord, kindly see, he relied upon 5 judgments, no copies have been served on me.
Written note, written
Kindly,
submission.
he relied upon all these judgments, it was not served on me. Now coming to the facts, my lord. The submission that was made that I have no locus, kindly see the genealogy I have given. I am a successor coming within the meaning of section.
Class 2.
Yes.
You are a class 2 here.
Yes.
That I know.
So that is how I have my locus. You have to succeed or fail on the basis of your own legs.
Your entire case is that in the absence of any issue, it will revert back to the other heirs of the.
And Justice Raghuveer Das judgment, your lordship will see, Gujarat High Court is not distinguished there. Only taken note, Gujarat High Court has said this. That's all. I have seen this. I have read it. The Justice Raghuveer Das has not distinguished Gujarat High Court. And secondly, 16 sub rule 3 has not been considered in any of the judgments.
All right. Hearing concluded, parties may file their note of submissions and memo of citations, if any, within a week.
Yes.
One thing, Milan, clarify, my land friend has replied. I said he has not submitted written note, which was he has argued.
Chalo,
I'm not
sir.
asking, but no. It is not at that level.
Sir, both of you are senior
Let us
counsel.
close it here.
You are senior advocates, sir. I will not say anything.
Let us close it here.
Yes.
Sorry.
No, may
Remaining matters are there in the weekly list, so we'll continue tomorrow.
Till
Whatever is. Again?
Till Friday.
Till Friday, actually, we'll cover that list by tomorrow. Kali maximum day after tomorrow with the surgery list. If ସେମିତି କଣ କହିବ ସେଦିନ ପଢିଲା ବେଳକୁ ଯାହା ହବ ନା ଗୁରୁବାର ଦିନ ମୁଡ୍ କଣ ଥିବ କି କହିବ ଯେ